I don't think you all understand who I am.
Her nickname's Grumpy the Bear. We know they drink from sunup to sundown.
I mean, I've always been a straight-A student. I am an outstanding mother to my son.
It's her day to pick up the kid, but
Okay.
it doesn't always happen. 1 or 2 days a week, maybe she gets them.
I excel at everything.
She worked for over 2 years. I mean, she was always calling to borrow money, and but it's been like 2 years since she got a job. She keeps on telling me she's looking, and she's always finding the good opportunities and everything, but...
Well, hello, everybody. How are we? The docket is burning hot today on the Sarah Boone case. And I really wasn't planning on recording anything because Sam and I recorded last night. We did a couple of pieces that are going to keep me busy for a while. But I can't not talk about this new stuff hitting the docket, and especially with us going into hearing tomorrow, which is actually probably today by the time you're watching this. So the first thing we've got here, let me pull it up. Motion to appoint clinical psychologist. Now, we've already gotten one of these before from James Owens. Dr. Brannon. I knew it. The defense requests the court appoint Dr. Michael Brannon, a clinical psychologist, for the defendant. Dr. Brannon is requesting and has been paid in other court-appointed cases at a rate of $200 per hour to perform his duties, including time spent traveling. It says that it looks like they want a $7,500 cap for that. We know how this works by now, right? In addition, reasonable coverage for travel and related expenses cap at $2,500. So can we have $10,000 more dollars? Mom, can I have $10,000? I need to go hire a psychologist. In court on September 3rd, 2024, the state indicated that it takes no position regarding the defendant's request. I don't know why he's just not so late getting this to them, because he talked about this August the 30th. They requested it. Yeah, why isn't it there yet? Why hasn't the judge already done this motion? They need to pick up the pace if they plan on being ready by October the 7th. I didn't realize I was covering up the document and everything. Judge Kranek has made it very clear that there's no extension. None whatsoever. Let's move on. Next item on there. The JSC response. Yeah, that's normal. That's normal. It's not a big deal. This is what they do. It's a process. They request it. The court comes in, gives them the go-ahead. They submit it to the JAC. Yeah, it's a process, but this is normal. But I just feel like it's awful late. Now, Dr. Brannon, again, he testified in that case we just looked at, Marsha Thompson. We're not done looking at it. I thought that was interesting. We're going to see if we can't find more on what he said about Marsha Thompson's case. If you watch what we've done on Marsha Thompson so far, you'll see it's obvious. There's no comparison between what her situation was and what Sarah's situation was. Let me let Sam on. Hello, Mama.
Hello.
Look at this.
Okay. I did not check her docket today.
I didn't either. Well, I was at the hospital. Oops, sorry, I'm not presenting.
Google Michael Berkland if you have not already.
Oh, Berkland.
What I said.
I thought you said Brooklyn. Okay.
No, Google him.
Okay.
And then tell me what you think.
Former medical examiner.
Mm-hmm.
Arrested.
Mm-hmm.
Well, they just, you know what? Oh, did they all meet in jail? Like, what the hell is going on with her defense?
Do you see what he was arrested for?
I didn't even look, to be honest with you. Allegedly
you need to look.
God, Sam, do we want to even go here?
I'm not putting it on here for your recording.
Why not? I want to be the first to say it.
So look at what he was arrested for.
He was charged with improper storage of hazardous waste, keeping a public nuisance, and driving with a suspended license. He was released on $10,000 bail. Crudely preserved human remains in a rented storage unit. I've heard of this guy. Is
that not terrifying to some extent? I've never heard of him before. So when I Googled him, I was like, okay.
Now, this all occurred, what's
like
the date on this?
2012? It's been a minute.
August of 2012. That's a long time ago. But it says he crudely preserved brains, hearts, lungs, and other organs and specimens were discovered in more than 100 containers last month in Pensacola storage unit that Berkland rented for about 3 hours.
Oh.
Rented for about 3 years. Was it rent by the hour? Rented for 3 years.
Like, what are you doing with all the body parts in 3 hours? I don't know.
The unit was auctioned off after Berkland defaulted on his payment, according to an arrest affidavit.
Can you imagine being the person that bought that unit?
I would be like, oh, hell to the no.
You know how people...
I'd sell the story to it. I'd sell the story to the tabloids to get my money back.
Yeah, I mean, people buy those. They bid on them, hoping there's something good in there. Can you imagine having bought that? Oh, my God.
The remains included tissue samples and dissected organs. The investigators also advised that there were numerous whole organs, including hearts, brains, liver, and lungs. He worked as a medical examiner's office in Pensacola in 1997. He was fired in 2003 for not completing autopsy reports. Oh, God. His license to serve a medical examiner in Florida was also withdrawn. Before arriving in Florida, he was fired as a contract medical examiner in 1996 in Jackson County, Missouri, in a dispute over his caseload and autopsy reports. His doctor's license was ultimately revoked there. The Pensacola Medical Examiner's Office said the organs found in the storage unit appear to have come from private autopsies Berkland performed between 1997 and 2007 at funeral homes in the Florida Panhandle and in Tallahassee. 10 families have been notified about their relatives' remains that were in the unit. Okay, this is beyond just grotesque, and this guy is not, he's a quack. Is that what they call the doctors that aren't any good?
Sure. But just imagine when the state tries to go after his resume, right? They're going to say, and were you not arrested in 2012 for XYZ? Unless the defense files a motion in limine to keep that stuff out because it's not relevant to this case. This is getting more interesting by the minute. As far as
that may not be relevant. That piece may not be relevant, but the fact that he's been fired twice for overgiving bad autopsy reports.
But they're not calling him for an autopsy, or are they?
What are they calling him for? We haven't even looked at
No, you might be exactly right. It may be for interpretation of the autopsy.
That's what I'm thinking. Why else?
Yeah.
Okay.
Well, the only other thing I can think of is he a person that can opine as to whether the suitcase went down the stairs or not with Georgian?
That could be reconstructionist. Oh God, we got to break the news to everybody on this. Breaking news! I'm gonna pull a Nancy Grace. $200 an hour, $10,000 initial cap. Oh, he's a big time money he wants. $2,500 for travel expenses. Okay. Yeah. Reconstructionist, crime scene reconstructionist, death investigator. I still think they can bring up the fact that he must not be very good at being whatever he does if he's gotten fired twice.
Possible.
All right. So let's go down we'll go further into this on another video. Right now, we want to just get this information out to you guys. I'll file a separate video on all of his stuff. Let's see. The next one, motion to appoint another expert. Dr. Harper. We already did this. That's all they're just asking for motion to appoint these experts so they can get JAC to pay for it, which is expected. It's just kind of cool that we get to now see who they're talking about. Now, Dr. Brannon is the one that worked with Marsha Thompson's case. We need to dive into that now and find out more about what he did and what he said on that case. Motion to declare defendant indigent for cost. That's normal. Mm-hmm. Shouldn't he have filed this a long time ago?
Yeah, it's a little weird right now, but it's amended. I don't know what has changed from the original. Number 7 is just indicating that they informed the JAC and the JAC came back with that. We have no position, so they're not objecting to it.
Okay, and then we've got this amendment motion for declaration of indigency.
What are they amending about that? Hold on.
What is that word? Non-pro-tunc?
Oh, nunc-pro-tunc. It means backwards to a date. Where are you seeing it?
Number 7.
Okay, so yeah, this happens to me all the time because I'm terrible about keeping track of my hours. And I'll go over how many hours I've been allotted on a case, and then I have to get a lawyer to come in and get me a new order and backdate it, is what that means to us.
motion for return of property, or in the alternative, motion for independent exam by defense. But it's not limited to text
Oh,
and
so
photographs.
this is insane. Wait, hold on, Carrie.
What the hell are they saying? Not limited to text and photographs?
So what they're saying is, I know that her phone had to have been downloaded. I just can't believe that it hadn't been. So only law enforcement could do that. Only law enforcement can extract the contents of a phone, and it's read by a program called Celebrate, and you can turn your search results into like a PDF, or you can say PDF the whole thing, and then you get a 20,000 page PDF.
Right.
So what they're saying here, okay, what I'm taking from this is either they didn't download the whole phone and they only pulled off videos and text messages and a couple of photos, and they just sort of manually removed those from her phone and didn't do an entire extraction, because all the contact information should have been there. So that's saying to me then that they didn't do a Celebrate extraction on her phone. They had to go in manually and pull out what it was they were wanting to see. And her thing all along has been like, can I have my phone, because I want it, my contacts information is in there. So this will be interesting. I am real interested to see how this one shakes out.
Well, and as we suspected, they want more time to look at the evidence too. Let's see. Let's go down to this one.
They're giving the arrest affidavit.
Pages 422 and 423.
So what happens is, as an investigation goes on, it becomes this really big document. And if you're lucky, if your sheriff's department is good at what they do, they will put in a table of contents in the beginning so you can go and find what it is you're looking for. But what this is telling me is they have already provided Sarah with pages 1 through 421, and now they're only providing 422 to 423.
Makes sense. So, but this wasn't in there previously. This dude's arrest affidavit. That is, if I remember correctly, that's one of her previous arrests, I think. So this is from the ASA, you guys. And look, it's William Robert J. It is not Cacciatore.
Do me a favor, go back to the top and let me see the caption.
They're just adding to the list of discovery. Yeah, okay.
They're adding her arrest affidavit, or an arrest affidavit. I'm not sure which one.
You know what that is from? I think that's from 2000 oh, snap. You know what I think that's from? 2018. I think that's the one where she was arrested in 2018 and they weren't going to bring it in. But now that he's wanting to bring in all these other body cam stuff, they're now coming back and going, okay, we're going to add the 2018 too, because we're going to be ready for that to be brought in. I just talked about this on my video the other day.
This fight is heating up. I'm kind of glad that Sarah's not representing herself, because that gets boring and annoying after a while. And this we may see lawyers battle it out, and that's far more interesting.
Mr. James Owens from Pensacola, down in my neck of the woods. Okay, what has Owens got here? Provision of defendant's amended witness list. So now he's giving his witness list to the state, correct?
Yes.
And again, it's not attached.
It's going to be under seal. Yeah.
Then we've got a notice of supplemental discovery.
Remember how I told you there's a rule, and a rule in Florida law, that from the date you file your notice of discovery, or demand for discovery, excuse me, if you're the defendant, the state is supposed to turn over your discovery within 15 days. I have yet to have that happen. So I'm my point in pointing this out is that we're getting close to trial, and look at what they're asking for, what they're offering.
Exactly. See, that's my sister calling.
Oh my God.
You wouldn't believe. See how you hear my dogs? Every time the phone rings, they get upset.
Well, if I had to hear that ring every time too, I would be.
You know what that ring's from, right?
No.
It's the Wicked Witch of the West from the Wise. That's my sister's tone.
Oh my God.
That's what I put as her tone. Everybody I need to put Munchkin Land because she's short. The inmate tablet communications records. That's going to be what happens on those? Tell us again, remind us again what those are all about. Can she do on
So
those?
they're kind of a dumbed down version of an iPad. My inmates using the tablet is that they can email/text message me. So I think I said this the other day, you can get up to 5,000 characters. So you could write like a long email, or you can kind of treat it like a text, which is what I normally do, is like, hey, I said I was coming. I can't come today. I'll come tomorrow. Or they'll reach out to me. Can you please, when somebody comes to see me, can you please come and see me? And so as far as the texting, well, any of the messaging, that is subject to review before it gets passed on to the inmate. And then a tablet, it you don't get to hold it all day by yourself. It's not like your personal tablet. It goes around. And to my understanding, it's got some limited movies and music. And I believe they can use it for the video calling with their families.
Okay, that makes sense.
So and I know people are going to say, there's no internet. There's absolutely no internet on those tablets.
They're wanting to see who she's communicating. There could be some stuff between Billy on there. What do you think they're looking for? This is
Inmate
Owens.
tablet communications.
No, this is the state pulling it.
Saying that they're providing it. This is the state saying they are providing it.
They're providing it, but why are they looking at it? I guess is what I'm saying.
Why is the defense looking at it?
No, why is the state looking at it?
Well, the state pulls it like as a matter of course.
It's normal.
The defense is asking for it. This is the state saying, we're going to give it to you. You need to give us a blank DVD-R and we'll give it to you.
Okay.
So it's the defense that has requested her tablet communications, which to me says that she thinks that there may be contact information or other useful information on there.
All right, let's move on to the next document. Notice of provision of state supplemental witness list, once again, which we're not going to see.
Yes.
So every time they add somebody new to the list.
So what they're doing here is, because the witness lists are not being released, is every time the state provides updated witness lists, they have to file a notice saying, yeah, we gave it to the defense.
Gotcha. I wonder if because Owen's starting to come in and bring all these other things up, now they're having to go backwards, the state is, and go, okay, well, we might need this deputy to come in and testify now because they're bringing this up. So we want to make sure we get this deputy on our list.
Yeah.
Does that make sense?
Yeah, 100%. Because as I've been trying to explain, and probably not doing it very well, is that you have to have a foundation before evidence can come in. And most of the time that's a witness of some sort. You bring the witness in, the witness is questioned to lay the foundation, and then they're able to move into evidence, whatever it is they want to move into evidence, which is like a physical piece of evidence.
Let's go over here to a notice of provision of defendant's exhibit list from Mr. Owens. So now he's got his list.
So he's saying that he provided his exhibit list to the state's attorney. Interesting. I cannot wait to see what that's going to be.
I know there's nothing on there. I wish we could see. All right. The last thing is, all right, defendant's motion for enlargement of time. And this is the big piece right here.
Okay.
This is the big dog.
Okay. So they're not asking to push the trial, and hereby moves this honorable court for an enlargement of time to file the defendant's witness list, digital exhibit list, physical exhibit list, and any objections to the state's exhibits, and for good cause shown. So what they're saying here is, look, Judge, we want more time to give the state all of our stuff because it's reciprocal discovery. His ask is for an expanded time frame, not for the trial.
I kind of figured that, but then I was like, okay, well, I don't think that's that big of a deal. And we kind of expected this because they were coming in so late.
Well, he's saying here that the defense is having difficulty locating witnesses and gathering evidence due to the passage of time. And yeah, cases fall apart. The further out you get, the witnesses disappear. They tell a different story.
Works both ways too, though. It could happen for the state as well. That's what's scary.
Yeah, but the state won't usually bring charges unless they have to have probable cause. So I wonder, can you scroll down? I'd like to see if he's asking for a specific number of days. Okay, so this set the matter for trial on the 7th.
Sending deadlines.
That says August 17th.
But it says that was the deadline set. That actually it was not the 17th. You know what? That's an error. They meant to write September 17th because yesterday was the deadline for them to file their objections on any evidence.
Okay, that makes sense. So here on the last one, this is where he's asking for something, which is he wants the court to enter an order extending the filing deadlines for the defense to file any objections to the state's exhibits and for the defendant to file witness and exhibit lists for the period of time up to and throughout the jury trial, which they're going to get pushback on that because the state's going to say, Your Honor, that is not fair. Does it happen? It does. But like we were talking about yesterday about motions in limine, and this deadline for defense to file any objections to the state's exhibits. So if it were up to the state, they would throw in every single crime scene photo, like everything. And this case is not as gruesome as some are. And so the attorneys will fight it out about, okay, judge, here's what the state wants in. And the defense is like, we don't want any of it in. And they walk out with 2 pictures that are going to be allowed in.
Right.
So that's what that is.
I could see him giving him a little bit of leeway, but he also has to have respect for the state. I mean, the state's been sitting here for 4 years waiting for this thing to go to trial. They've had their ducks in a row. Mm-hmm. And yeah, you knew when you came into this, you knew you had the time limit. He was pretty strict. He was pretty straightforward. You know what you're up against here.
Absolutely. And the other thing, I mean, he's referencing investigation. Billy has been the investigator on this case forever.
That's true.
He knows it better than anybody, and I know him to be a very good investigator. So unless they have uncovered something new and different, I could see the judge saying, you've had 4 years, you've had 8 lawyers, you've had this investigator. How much more is out there that you think is missing?
Hey everyone, how are we? I am now technically live with Florida private investigator Sam.
Hello.
How are y'all? How is everyone? I started a little early, Sam, because I was getting antsy. I couldn't help myself. Okay. I've been up all morning drinking lots of coffee, and I had a couple of things come up. And let me show you guys this great news clip that I found. It's coming. Bear with me. It's coming.
A closer look at a former Florida medical examiner who authorities say had kept body parts hidden in a Pensacola storage unit.
We're, of course, talking about former medical examiner Michael Berkland. As Fox 10 News reporter Andrew Perez explains, it's not his first time getting into trouble.
That's right, Bob. Letitia, we introduced you to Michael Berkland back in 2007 after medical officials say he failed to complete more than 100 autopsy reports in Northwest Florida. He was fired for it, ultimately had his license pulled. But at what point does a doctor's actions actually become criminal? Authorities say Berkland was walking that fine line. A warning, some of what you are about to see may be disturbing. We trust doctors with our lives, but we also trust them in death. A medical examiner's job is crucial to solving criminal cases or determining death benefits. More importantly, it's closure for families looking to heal.
The family wants answers to why their loved one's deceased.
Director of the District 1 Medical Examiner's Office, Jeff Martin, says it's closure, though, that's been undone for some families across Northwest Florida. Tucked away in a storage unit in Pensacola, authorities found more than 100 human organs and tissue from more than 100 different bodies. The renter of the unit, former medical examiner Michael Berkland.
We found complete human hearts. We found complete human brains still intact. They hadn't been dissected or sectioned, which normally that's the part of the autopsy process is to actually look at the tissues.
Reports show Berkland's unit B12 reached default status for failure to pay on at least 6 different occasions. Each time he settled just before repossession, but in August the unit was officially seized and sold at auction. Martin says the parts found inside were 10 to 15 years old, all retained from private autopsies Berkland had been performing on the side during his career at the medical examiner's office. Now, about half of these parts and tissues, investigators say, were stored in things like styrofoam cups. They were also wrapped in things like sandwich boxes and Ziploc bags. The other half were stored in actual containers. Investigators say it doesn't appear that Berkland actually had a reason to keep all these parts.
Looks like he's kept pretty much everything that he's kept or that he's performed an autopsy on while he's been in the state of Florida. I mean, there's so many. It doesn't look like they were just random selected cases that he kept.
Berkland worked at the District 1 Medical Examiner's Office from 1997 until 2003, when he was fired for not completing autopsy reports. The ME's office says he was given several chances to complete them, but he never did. And complaints from family members, they kept piling up.
It's the worst thing ever. It's a nightmare.
Michelle Helderman says she's been dealing with Berkland for years following the death of her baby back in 1998 in South Carolina.
I was in the hospital for about 6 hours in labor. He had a healthy heartbeat, and I wasn't dilating, so they decided to do a C-section.
Doctors told her the baby was stillborn, but she had her doubts. In a deposition, a midwife testified that she felt the baby's heartbeat. Helderman moved to Pensacola in 2001, and by 2004 had the body exhumed so that Berkland could investigate.
At my house, he looked over all my paperwork and said that, you know, he would help me out with my case, and then he had thought that there was some, you know, something fishy about everything.
She claims she paid him $4,000 for an autopsy and DNA test. She says she was shocked when the results came back from the lab.
No results, no DNA.
Helderman says the body was fully intact and was told by the DNA lab that it may have been tainted. She says Berkland's autopsy came back more than a year later with no new information. At this point, the medical examiner's office says there's really nothing they can do for Helderman. The office, however, says it's gotten numerous complaints from families throughout the area with similar stories about Berkland.
Our big thing in this that we've heard from a lot of families is that they just never heard back from him. I mean, these are cases where, you know, the families would pay him to perform the service, and then he would never issue autopsy reports in the cases.
We've tried to reach out to Berkland for his side of the story, Both of his known addresses, though, are vacant. We also paid several visits and put in numerous calls to his attorney, Eric Stevenson. At last word, Stevenson said they are currently working on a defense, looking to explain just why Berkland kept so many organs and tissue for so long.
His lawyer's quoted as saying he's storing them there just as he would, as a lawyer would legal files.
Florida State Attorney Bill Edens says Berkland is facing hazardous storage and public nuisance charges for now. But given the bizarre circumstances, he says he's expecting to add theft charges to that.
We had a conference call with all 20 state attorneys from throughout Florida shortly after this, and I asked if any of them had any experience with anything of this nature, and nobody had.
A lot of these families that we've talked to had no idea, and so making that telephone call to them and trying to explain to them that we actually have the brain or the heart of one of their loved ones, it's just extremely shocking to them.
Authorities expect to make a formal decision in the coming week. For now, it appears we've not heard the last of Michael Berkland.
Now, records show Berkland also had his license revoked at his last job in Missouri for not completing autopsy reports. Authorities say he has pleaded not guilty in this current case. Berkland has a court date on January 9th, then trial set for January 22nd. We'll let you know what happens with any additional charges.
So I have done more on this, and we can play that now if you'd like. But before we get into all that, I guess we need to kind of update everybody, because I came in guns a-blazing. I barely even said hello to everybody. I was like, we're live. Here you go. So
I can't believe you went and dug up that footage.
Why not? Well, why not? That's funny because it came from my hometown, that video.
Oh, yeah.
Okay. Let me play this for you guys. I did a little bit for y'all this morning to get some more information on this. But this guy, now, before we do that, there's one more thing that came on the docket this morning that we have not touched on. We just played the video on everything up until this document right here, Sam.
Girl, how much coffee have you had today?
Can you tell?
Yeah, a little bit.
Yeah. I am
CB,
strung
no, it hasn't
out.
started yet. It'll be at 1:30, the live, her hearing. Sarah's hearing's at 1:30. We just came on early so that y'all could say hi to each other.
Yes. I might have to play that other because that's 15 minutes away. So we probably should save that other thing on that doctor till after that the hearing's over. I think the hearing might last an hour, you think?
Super Kelly G, that's funny. I don't know. Actually, I was thinking about that on my way here to get on here with you, and I don't know, because is James Owen, he's appearing via Zoom, right?
Yeah. But I imagine he's going to be doing a lot of talking still.
Yeah, and I wonder if the other two attorneys are going to be present. The crawler is saying 1 because she opened up the live at 1, but the hearing is at 1:30.
No, I messed up. Let me edit that. I'm making all kinds of mistakes.
You're fine.
Let's see. I got too many things going on. It's like when it rains, it pours. Does that make sense?
Of course it does.
And it literally, for me, has been raining and pouring for 2 weeks. Sam got the brunt of me last night. I was like,
I was trying to go to bed early too. Oh my gosh. Yeah, you guys, so Sarah's hearing is going to start at 1:30. Carrie opened up the live stream so you guys could say hi to each other and check out some of the unusual things we've uncovered in the last week or so.
all right, let's talk about this document, Sam.
Yes, ma'am.
The state is responding to their motion.
Oh, is this new?
Yeah, this came on this morning.
I've been out of the office all day today. Okay. All right. It's new. Let's go.
The defendant's assertion that this is so funny, y'all. The defendant's assertion that her prior plethora of attorneys had no opportunity to see or review her cell phone is that patently false. If they never chose to avail themselves or or a retained digital forensics expert of the opportunity to inspect the phone, it was of their own volition. Volition. I should have let you read that. Why don't
That's
you read
okay.
the rest of it? No, you read the rest of it.
I believe she did have such an expert. His name is John Sawicki. The digital imaging of the phone has been disclosed in discovery. The defendant can choose to attempt to enter portions of the digital imaging, like the state, at trial. The state will introduce the physical device into evidence at trial. While it appears to be axiomatic, I hope I said that right, that a court cannot order the state to release evidence it intends to introduce in trial, it apparently bears repeating, as a matter of course, courts should not order the state to return property lawfully seized pursuant to a valid search warrant where the state is actively conducting a prosecution. So this is coming out of the pleading. My days are mixed up. So we saw a pleading where they wanted to take the phone and go try to get their own download of it, which is very odd. I don't see that happen a lot. I'm not sure why that's happening now, because her phone was, subject to a Cellbrite extraction when it was first received. And if I'm not mistaken, one of the experts was John Sawicki, who is a digital phone guy.
Mm-hmm. He was. I have to pull my notes up.
So
Yeah.
LW, incompetent lawyers didn't look. Well, I think maybe it could be that there's been so many lawyers. So I don't know.
Well,
Yeah,
and it's not. Here's the thing.
Vocabulary today.
This is exactly, and I'm off for the state coming back with this because this is exactly what they knew was going to happen when a new attorney came on, and the judge even warned them. You don't have a lot of time. This isn't your first rodeo. This is a big case. I mean, it's pretty cut and dry, but we know you're going to try to put on a big case. So
there's not a lot of, they make such a big deal about the evidence. I don't believe there's a lot of evidence here. I'm working on death penalty cases with 5 co-defendants. That's a lot of evidence.
Yeah. This is pretty. One person involved, one deceased.
One piece of luggage.
Yeah. 1 Dr. Pepper, 2 bottles of wine.
Yeah.
And a pack of cigarettes. I'm looking for my notes here that I had made about the different when Padilla came on. Now, so guys, I got to back up a little bit because I forget that some of you guys aren't as, I guess, tuned into this case as I am. I have been living, eating, and breathing it for 4 months now. So Padilla was the first attorney that was assigned. Well, technically, he was the second attorney that was assigned to Sarah's case. The first attorney.
He took it
the first
coalition. It was his thing.
Yeah.
He wasn't appointed.
Oh, good point. Okay. So the first one that was appointed, got appointed, and then this guy comes out of nowhere and he's like, I'm going to take the case or whatever. He took it pro bono, but he still was getting money from the JAC. So he got a lot of things lined up. He was on it for 2 years. He got a lot of things done. His name was Mauricio Padilla. He was actually the one that hired her current investigator, that Billy Lane, that we've talked about many times. He hired John Sawicki. Who else did he hire?
J.D. Thomas.
J.D. Thomas. And J.D. Thomas does what does he do?
He's like a forensic ballistics crime scene guy.
Okay.
But he's not a death investigator. So they're asking for a new expert that is a death investigator. So we are just kind of, there was already people in play on this 4 years ago when this first got started. Right. Yeah.
So, and the one key element, the person that's been on it as long as Sarah has, no pun intended, is Billy Lane, the investigator. So I would assume that with all these different attorneys, even though they're coming and going, he was still kind of trying to, I could see where he would kind of help things speed up a little bit. Go, well, this happened here and we were doing this here and this is what we were doing here. Am I correct in saying that, Sam, that he would be helpful? Not
yes.
Just kind of saying, well, this is the kind of this is the direction we were going. This past attorney was
I
going.
don't know that he would advise on a defense, but I know that he would have taken, would have had a lot of detailed notes. Anything he would have sourced would have been scanned in. He's very, very thorough, but he wouldn't be able to say to the attorneys, this is the defense. Sarah might say, hey, this is what the last attorney said, and this is what I want, which we know are two things that do not go together.
Yeah.
So
Yeah, no
is
doubt.
Billy Lane helping or doing a job for a client? Billy is getting paid by the Justice Administration Commission, which is the same way I get paid. And we have a video where Carrie interviews me and I explain the whole process.
Yeah, there's a whole video. It's entitled something about paying the JAC. It's the only one that we really have about that.
It says PICM on the front of it.
And
think of the therapy, Kirsten. I mean, and we only get paid $50 an hour, so it's not like,
Yeah, they're not making millionaires. Sweden in the house, Linda. That is so cool. Welcome in. Kind of looking at the chat a little bit.
I love the way that the state is just snapping back. Somebody is having a good time writing these motions or these responses. Oh, I meant by helping, believing her story versus just a job client. If asked an opinion, we may give one, but as we tell everyone, our opinions are not legal advice. Billy was a former law enforcement officer, so he has an interesting perspective to be able to talk with the clients about their case. Billy Lane is the one who needs to write a book. Yeah, exactly. He does.
I'm going to share screen. We're just waiting for Law and Order. Law and Order. We're just waiting for it. I do that all the time. We're just waiting for Law and Crime to bring it up. And while we're waiting, I'm going to go grab another Diet Coke because I've only had 4 this morning. So hang on.
Okay. All right.
That and my 10 cups of coffee. Hang on.
It's nice to see all of you guys tuning in for a midday hearing. Yeah, Michelle, I think the interview will be, if you can go back to the interview she did with me, it explains a lot about what you guys have been seeing over the course of covering this case and how the JAC plays a role and how investigators like me play a role in these kinds of cases. Mark, don't be obnoxious, please.
Is Mark obnoxious? I love
He's
Mark.
calling you weird.
Oh my God, he's so wired. No, he said wired.
Wired. Oh, got you. Yes.
He calls me Princess
in
Bay.
the UK.
Okay, guys, Mark, you'll get a kick out of this. Listen to what happened last night, and I probably am sharing too much, but it's not funny, but it's kind of funny. So you guys know that my uncle's went into surgery this past week. He went in on Tuesday, and I wanted to say thank you for everyone who gave prayers because he came out, everything is fine. So he was in he was in ICU on Tuesday evening and all day. Well, most of yesterday. I got a call at 7 p.m. last night that he broke out of the hospital.
Oh, yes, I remember.
I was on the phone with Sam, and I was like, at first I was stressed out about it, but he's home. They went and picked him up. He's home. When I say they, I don't mean anybody crazy. I mean, like, my aunt went and picked him up. But you know what my brother-in-law said, Sam? He goes, "What? Your family is freaking crazy."
I love it that he broke out of the hospital. That's fantastic. In his hospital gown, nonetheless.
Oh, yeah. I had taken his clothes because I was over there yesterday, and he was acting really antsy. And he's done this before. He'd done this before in his first surgery 10 years ago. And so I told my aunt, I said, I'm going to throw this blanket on top of his clothes because he had him laying out on the bed. I said, yes, he went AWOL, Bama. I said, I'm going to throw this blanket on top of the bed where he's got his clothes laid out. And when I go to pick it up, when I leave, I'm picking up his clothes underneath it. Because if he saw me do that, he would have like gotten so mad at me.
Right.
We fuss and fight like brother and sister. So I was like, all right, I'm gonna do this. So I get it and I pack it all up. We walk, and my aunt just starts laughing. She's like, "Oh, that was so smart! I can't believe you did that. That was awesome." So when she called me last night and said, yeah, he broke out," I said, "Did you take him his clothes? Did you take the clothes back to him?" She said, "No, he's standing out there in his hospital gown and underwear."
Did he have shoes? Did you take his shoes? Did he have shoes?
He did have some shoes in one of the bags. I don't know if he had put them on or not. He probably had those stupid socks on that keep you from sliding on the floor. But that would have been a sight if he'd had his tennis shoes on with his hospital gown. That would have definitely been a sight.
Right. Totally.
So yeah, you guys, that's what I've been dealing with. So I had to get up early this morning because I wanted to do this with you guys, and I wanted to be prepared for this stream. And then after this is over, I got to go over to the house and be his little nursemaid. After I smack him on his head for doing what he did. Oh, we have feed. We have feed. They have not turned the volume on yet, but our volume is working, just so you guys know. Yeah, thank God he had underwear on. Guys, my uncle, he is a hoot. He is such a hoot. And he's not mean or anything, but one of the girls at the nurses, she was like, "Oh, he's been getting me hell all night, Craig." I said, "Don't take it from him." Hang on, guys, I got to see. Ugh, I have been sneezing my head off. So, yeah, I was like, don't put up with his crap.
Yeah, really.
I told him I was going to shove his Jell-O up his butt if he didn't being so mean to everybody.
Oh, no.
So, yeah, but his surgery went well, and so far everything's okay. And he did spend an evening in ICU. Yeah, normally my life is not this exciting, April. It's really not. I'm pretty freaking boring usually. But like I said, when it rains, it pours. Because I didn't have anything really going on my channel that was like, with a deadline, like a case like this for a long time. So as soon as I do, now I've got all this other stuff going on.
That's how it works.
Looks like they're in the same courtroom, Sam.
Yeah, I think
audio.
If they move courtrooms, it would just be for the trial. And I don't know what their policy is going to be on letting the public in. I mean, obviously courtrooms are open to the public unless they're federal. But I don't know, because we looked at the courtroom. I'm not sure how big it really is.
Well, what's going to be different about today is that Sarah's going to be over in the jury box again because yeah, she'll be over there, but her attorney's going to come in on Zoom, you guys. He got approved to do that.
Right, because he's in the panhandle of Florida, Pensacola, right?
Yep. He's up in Pensacola. He's actually he's probably like 45 minutes to an hour away from me.
The other two lawyers that have come on since him, are they up in the panhandle also?
Yeah, they're all buddies of his.
Okay. Oh, right. Okay, yeah.
Yeah,
yeah. I remember.
They're all buddies of his, and they all have a history, but we prefer not to talk about it here on this channel.
Right, exactly.
That's like me saying something without saying something. You know what I mean?
I know. It took me a moment.
But you guys, if y'all want to know more, you'll have to dive on your own. Because I have my limitations. I would like to hear
underwater. Come back.
Look at Mark. He's such a smart ass. Mark,
yeah,
I did a video one day, and I was reading up on personalities, Mark, and obsessive personalities, in fact. And in there, it said something about compulsive gambling. And I referenced you. Were you listening when I did that video? Because I did reference you. They have the casino over here's got the Beatles, like this band that looks and dresses like the Beatles.
Oh, wow.
Yeah.
A Beatles cover band.
Yeah. You guys, the only reason I'm not talking about the case is because as soon as we start talking about a topic on the case, they're going to go live. So I'm just trying to kind of kill some time.
Yeah.
Do I really sound wired? Like people are going to stop watching me?
No, you're fine. You sound very energetic. I had to give up caffeine. I had to break up with it Made me very sad. There he is. Hi, Mark. He cried for hours.
When we were watching the Daryl Brooks trial, Mark was like one of the few men in the chat, right?
Mm-hmm.
And he would come in and just keep all of the ladies cackling. He
I
got so
bet.
much attention. He loved it.
Mm-hmm. I bet. So what do we think for this hearing today? Think Sarah's team's going to win any of these motions? Oh, there she is.
Did she get a new haircut? Does she have Farrah Fawcett back? No, why does she get to sit there?
Oh, because she's got attorneys in the room. So this is how it is when I'm in trial. I get to be at the big kids table with the attorneys and the defendant. And remember, I told you a while ago, like the jury would never see her feet, and she would be unshackled during trial, wearing civilian clothes.
J Popsicles. Do you put vodka in your Dr. Pepper? Tweak. I am tweaked. I'm tweaked now.
We see you. Pauly D's standing up for being in the chat during your Brooks coverage.
Wait, Owens is there. Maybe it was the other attorneys that are trying to come. Yeah, there's Owens, y'all.
That is Owens, isn't it?
So they're going to bring the other attorneys in on Zoom.
Well, one of these two on either side, or both of them, has got to be an attorney or a paralegal or a legal assistant, or they wouldn't be there.
Girl. That poor girl. Both of them. Oh, there's two women there. Oh, I hate to work. Okay, so let's just talk about the funny elephant in the room. Yosemite. Yes, Yosemite is not Yosemite. It's Yosemite. And then I did a video that popped up earlier this week, and I said Yosemite instead of Yosemite in it. And I didn't just say it once. I said it several times.
Mm-hmm.
And I'll never be able to live it down.
Mm-mm. Mm-mm. So now Sarah has gotten a huge team, all kinds of attention. I mean, Billy's probably glad that he's not stuck in the spotlight with her now. The two women are fashion consultants. Yeah, Sarah's hair does keep getting shorter and shorter.
She really should let it grow out.
Yeah.
Owens will not miss any opportunity to talk or be on camera, LW.
Exactly. He likes to talk. So I would expect a courthouse press conference, Carrie, when this is over. So we might want to keep an eye out for that, because he will definitely go out and talk to the press.
Oh, thank you. I'm glad you said that, because you're absolutely right. He will, won't he?
Yes, he will.
I'm trying to
And then
remember.
he'll call Vinnie Politan later over on Court TV. He'll call in and have another one.
He would probably come on if I asked him. I'm not going to ask him.
He might.
I don't want to talk to him. Let's see. It was WKMG News 6 that had him on after the last one. So I'm going to go to their channel and be waiting for them over here.
Sarah's all smiles today. Look at her with her legal team. This is just crazy how this all worked out. In the course of a month. Yeah, she got a big smile on her face.
These women around her hate her. You know they do.
I mean, they know they're on television.
I wonder if she has any staples in her pants today.
I thought they put a stop to that.
Looks like they're having a little bit of trouble with their feed.
Yeah, it sure does.
You know what I just totally didn't think about? That Madeline Soto case is also in Orlando. A lot going on in Orlando in the trial world.
Mm-hmm. Yeah, we're special state. We have a lot of crime.
Creative word to use there. Yep.
Mm-hmm.
Aw. Thank you, Rhonda Wise. I used to live in Florida, so I don't really make it that. I don't make fun of Florida. Like, I only do it sometimes.
I moved here by choice, so I accept the ridicule. And then I chose to work in criminal defense, so I guess I'm getting what I asked for.
You are. You're double dosing it down. Yes, you're exactly right, Addie. That's exactly what I was thinking of when I read it.
A special state. No,
Right,
Billy Pinnacle, Billy Lane, the investigator, is being paid by the Justice Administration Commission. He is not doing the work pro bono. I heard Mr. Owens say that, and he misspoke. It's not true.
Oh, Laura. Is it Laura? Laria?
Laura, I don't know.
I watch her go. It's just Laura. It's just Laura, Carrie. You know I mispronounced
Mariah?
everything.
Like Mariah? Is it Mariah? Like Mariah?
Yeah, Mariah with
I
an
don't
L.
know.
I loathe her. Is Yanni in the chat? Yanni, I didn't see you. How you doing? Florida is entertaining, Pamela. You are absolutely right.
That's correct.
They changed camera angles. They really need to go around to the side, Michelle. They need to
I don't think they were prepared for Sarah to be at the defense table.
Well,
She's usually in the jury box.
They never fixed it last time either, though, when she was sitting at the defense table.
How long ago was that? Because it feels like it was a year.
That was August.
So what's with the pro bono motion Owens filed? Will the state confront him on that? No, he was just clarifying that he was not getting paid, that he had accepted the case pro bono because he'd left it kind of mushy and gray during his press conference. He said, Sarah owes me. And then he also talked about Billy, and he said, Billy is doing this pro se, which is not true. Billy is being paid the same way that I get paid. So he refiled his notice of appearance and put it in as pro bono, I believe. So that would clear up any of that. And then I believe 2 more lawyers have filed.
I have my headphones on.
Oh my God, oh my God.
Judge, I'm James Owens. I represent Sarah Boone. I have co-counsel.
Thank you, Mr. Henderson. Thank you, Mr. Owen. Any other appearances on behalf of Mr. Beck? Good afternoon, sir.
Kevin Beck on behalf. Good afternoon, Your Honor. I'm Kevin Beck on behalf of Sarah Boone as well.
Thank you. I'm going to moot Messrs. Beck and Henderson for the moment. We seem to be getting some feedback.
Thank you, Judge.
If they need to speak, we can address that if and when that's necessary. We're here this afternoon on a litany of hearings. The court did receive the state's response to the motion to return property, which just filed yesterday, and the state's amended notice or amended motion to strike defense. The court was reviewing the authorities cited therein, which is why we're a few minutes late this afternoon. Are there any housekeeping matters, state, that we need to address before we begin this afternoon?
Not from the state.
All right. Any housekeeping matters from your side of the ledger, Mr. Owens?
Judge, I appreciate being here, and I just wanted to introduce my 2 assistants that are helping me, Shelby Andrews and Lauren Henderson.
Afternoon, y'all. Anything else, sir?
No.
Okay. To the extent we may be hearing from Ms. Boone, ma'am, if you could, please raise your right hand. Madam Clerk's going to go ahead and swear you in. I believe that the first thing that was filed in this case, just as a matter of time, was the state's motion the defendant's motion for statement of particulars that was filed on September 2. I've reviewed that. Mr. Owens, you may proceed, sir.
Judge, do you want me at the podium?
However you feel most comfortable, sir, but because we have your co-counsel appearing virtually, I would ask that you direct any argument into the microphone so that they might be able to hear it, sir.
Judge, as you know, I filed on behalf of Sarah Boone this motion for statement of particulars, and in my motion, I quoted the language in the information that she was charged with. And the pertinent part charges Sarah Boone on the 23rd day of February of 2020 in said county, Orange County, violated statute 782.04, paragraph 2, by an act eminently dangerous to another and evincing a depraved mind regardless of human life, did kill Jorge Torrez. Judge, that's about as bare bones of an information as you can file in a case. You know, anytime there is a weapon used, it's usually shot with a firearm that was used, that type of language. That is as bare bones. It doesn't even spell out all the essential language of the jury instruction, which I followed. To prove the crime of second-degree murder, the state must prove the following three elements beyond a reasonable doubt. 1, the victim is dead. 2, the death was caused by the criminal act of the defendant. Now, there is no language in the information that alleges what criminal act Sarah Boone committed that caused the death of the victim, Mr. Torrez. This is a unique case, Judge. It does not involve a firearm, which I believe many of these cases do. I'm sure you're well aware, the state's well aware, the defense is well aware of the report, the videotapes in this case, and the overall general facts about the suitcase and Mr. Torrez being in the suitcase, asking to be let out by Ms. Boone. But the state, in their charging document, has failed to say exactly what it is that they believe is the criminal act that caused the death by Sarah Boone. Some information that the defense could receive from them so that we could properly prepare a defense for Ms. Boone. In count 3, the unlawful killing of the victim was an act eminently dangerous to another and demonstrating a depraved mind without regard for human life. It goes on to define an act as a series of related actions arising from or performed pursuant to a single design or purpose. We have no information, no particulars in the information that explains a series of related actions arising from and performed pursuant to a single design or purpose. None of that language is in the information that would let us know what it is they're claiming that she did or series of acts that she committed that constituted the cause of the death of Mr. Torrez. The definition goes on to explain that an act is eminently dangerous to another or demonstrating a depraved mind if it is an act or series of acts that, 1, a person of ordinary judgment would know is reasonably certain to kill or do serious bodily injury to another. What is the act or series of acts that an ordinary person of ordinary judgment would know is reasonably certain to kill or do serious bodily injury? 2, is done with ill will, hatred, spite, or evil intent. What acts or actions by the defendant did they present or will they intend on presenting in the trial that would tend to indicate that she had ill will, hatred, spite, or evil intent towards Mr. Torrez? And 3, is of such a nature that the act itself indicates an indifference to human life. Again, some explanation that give the defense, my understanding of the rule of criminal procedure, the defendant has a right to know the charges against them with specificity. Upon request, the state must provide specificity and clarification on the details of the alleged offense in order to minimize surprise at trial and ensure that the defendant's rights are protected. The rule requires that the information shall, in plain, concise, and definite written statement of the essential facts constituting the offense charged. In this case, based on the bare bones information that has been filed in this case, it fails to inform the defendant and the defense counsel of the particulars sufficiently to enable the defendant to prepare a defense. Thank you.
Response.
Hi, Kova.
Judge, the state stands by its written response that was filed on September 5th of this year. In addition to that authority that is cited therein, the state would also cite State versus Pajon, P-A-J-O-N, 374 Southern 2nd, 1070, Florida 3rd DCA, 1979, and Sutherland versus State, 305 Southern 3rd, 776, Florida 1st DCA, 2020.
Can I have the second citation again? 305 Southern 2nd.
Southern 3rd, 776. And what all these authorities stand for, dating back to well before there were any discovery rules crafted in, I think, 1968, is the position that it's an extraordinary remedy to be given a statement of particulars in a case. The information in this case tracks the statute. That is what is required. There is nothing confusing about it. There aren't multiple allegations of second-degree murder on the same day, leaving her confused as to what we are talking about. There is no exposure to double jeopardy. There's no element of surprise. The state of Florida has provided discovery to the defendants in 2020. The state waived any opinion work product arguments that it had under Williams versus State in going ahead and providing the defendant exactly which exhibits we're going to enter in a trial, exactly which of the witnesses we've disclosed will be called at trial. And their motion does not set forth why it is specifically that they don't understand what she is accused of doing and how. In fact, opposing counsel cited the videotapes, the videos that were taken on her phone while the decedent was in the suitcase begging to be left out. And then what they didn't mention is what she said during these videotapes, which certainly would constitute the mens rea for second-degree murder. So it's our position that they have not stated why it is that a statement of particulars is necessary. It's an extraordinary remedy. They have all the discovery. Not only do they have all the discovery, they have the narrowed down list specifically as to what will be introduced. And they are clearly on notice of what constitutes the acts and the mens rea because they have mentioned those videos that were taken on her phone. So it's our position that this is not one of those extraordinary cases that necessitates a statement of particulars. There are cases where, for example, somebody commits multiple acts of battery against a victim, perhaps an hour apart, 2 hours apart, and comes back, and it's unclear as to what the state is talking about. If counts 1, 2, and 3 all say battery on X day, there are informations and indictments that span years that don't get statements of particulars articulated to the defense. In this case, the date is specific as to February 23rd, 2020. The metadata on the 2 videos that were taken from her phone are both from the 11 p.m. hour of February 23rd, 2020. Given all the discovery in the case and the amount of narrowing down that we've already done, there is no need for a statement of particulars in this case. Thank you.
Thank you. Any response?
My understanding of the law is the court has broad discretion on this issue about whether to require the state attorney's office to give more particulars about the offense. And this is somewhat of a unique case. And the state attorney just mentioned where there was prior incidences of violence or battery that occurred prior maybe to the death and whether or not that was relevant or admissible. That's the case we have here. Judge, I'm sure you're aware that Mr. Torrez suffered from some blunt force trauma that was unrelated to the death. The medical examiner who did the autopsy took photographs and described that there was blunt force trauma on Mr. Torrez's body that did not cause the death, that was unrelated to the cause of death. And that information has not been detailed whether or not it's relevant to his death, whether or not they're going to try to tie that in to Mr. Torrez's death. And if not, if we're relying on the medical examiner's explanation of the cause of death, which was asphyxiation, suffocation, then there's a question about whether that information is.
But is there anything that's missing under the statute? I understand your reliance on the jury instructions, but What's your response to Mr. J's position that it tracks the language of the statute wholly and completely, which it seems to?
Well, I have the rule for motion of particulars then. If that's the case, then in every case in the country, you just have to track the statute, and at no time a court would ever order a motion for statement of particulars.
But the date's there, the time's there, where it happened is there, the underlying charge is there.
I understand, and I explained that this is not a shooting where death would occur fairly quickly after multiple shots, that this was an unusual death, asphyxiation over a period of time, which we don't even know whether it was the day before or the next day. There's questions about that. The injuries, the blunt force trauma that the medical examiner is claiming that they're there, I believe is going to testify they could have been there 24 to 36 hours before. We don't know when those prior injuries were. They're fairly fresh, but they can't state that they were close to the time of death. Again, they weren't related to the cause of death. So there are situations in the law based on the unique set of facts that a court feels compelled, yeah, I have the discretion and I feel like for the defense to properly prepare for this case due to this unique set of facts that I think there are some details that you must give. There's blunt force trauma. We don't know exactly when it was. We know it was fairly recent. And the medical examiner says the cause of death is asphyxiation. He doesn't know where it was environmental or not. He gives two explanations. So there's a real question about that. And of course, we'd like to know what theory they're going under and whether or not they're intending to introduce evidence of this blunt force trauma that occurred sometime prior and what exactly they're claiming that she did. That constitute, is it just the video, the 2-minute video that everybody's seen, or the suitcase video? Is it that? Because there was a lot that occurred prior to the video. There was a lot that occurred after the video that's not on the video. So is that what they're referring to in this narrow window of just tracking the statute? And I go back to, there wouldn't be this rule in the criminal procedure if there wasn't a time when a statement of particulars was necessary. Thank you.
All right, thank you, sir. The court has reviewed the motion, reviewed the authorities provided, including the additional authorities, State v. Pajan, 374 Southern 2nd, 1070, and Sutherland v. State, 305 Southern 3rd, 776, and relying on State v. Peel, if the indictment is sufficiently full in its allegations of fact constituting the crime charged to enable a person to plead to it, the greater part of the reason for allowing particulars does not exist. The application was not so much for a bill of particulars as for a detailed statement of the evidence by which the state proposed to prove its case. If the defendant was advised of the nature and the cause of the accusation against him and had notice of the dates on which the acts constituting the offense were committed, there was no necessity for the bill of particulars. All this information was given in the indictment. And that is at 154 Southern 2nd, pinpoint 912. It sounds like, based on your argument, you're looking for the particular evidence as to the cause of death and the meaning of the death, which, based on Peel, is not something that falls under the ambit of a motion for particulars. So reliance on State v. Peel, understanding the age of this case as well, understanding there have been multiple lawyers who have filed responses denying the charges in their notices of appearance, your motion is denied, looking at the totality of the circumstances. Thank you.
Whoop.
Moving now to, give me a moment. And I think we could probably address these collectively. The defense's motion for additional discovery filed September 2, and the defense's second motion for additional discovery filed September 6th. Similar to the first motion, the court has reviewed all the authorities and those motions. Mr. Owens, you may proceed, sir.
Can I approach the bench?
Yes. Thank you, sir.
Judge, we're going to handle these both collectively, and I believe we should. The first motion for additional discovery was filed on September the 2nd at 8:30, and then the second motion for additional discovery was filed on September the 6th. The first motion refers to the rule 3.220F for additional discovery. On a show of materiality, the court may require such other discovery to the parties as justice may require. Specifically, the defense is requesting the Office of the State Attorney to provide a written policy of the Orange County Sheriff's Office relating to in-house interrogation procedures, in particular the policy in place at the time of the interrogation of the defendant at the Orange County Sheriff's Office, which was back in February of 2020. And then the second motion for additional discovery, specifically, the defense requests the Office of the State Attorney to provide the standardized Miranda rights written policy, the form, and the card of the Orange County Sheriff's Office relating to Miranda rights form utilized and read directly to any suspect before the interrogation. Now, the argument by the state is well taken. The defense does have a duty to try to gather the information independently of the state attorney's office. And we did make a request to the Orange County Sheriff's Department back on September the 10th. And the request was for the written policies and procedures of the Orange County Sheriff's Office relating to the in-house interrogation procedures, in particular the policies and procedures in place in February of 2020. And the written policies number 2 and procedures of the Orange County Sheriff's regarding Miranda rights, written policy, the form and the card relating to Miranda rights utilized and read directly to the suspect before any interrogation in effect in February 2020. So as you know, Judge, I don't know if you've actually watched the 2-hour interrogation, but the day after this event, she was asked to come down to the Orange County Sheriff's Office under what my client believed was something other than an interrogation. When she got there, she was directed into a room. And I don't know, like you said, you haven't had a chance, but there are some serious issues about whether or not that was coerced.
Oh my God.
Whether or not Miranda rights were fully read. I do not believe they were. I believe some of the statements that the lead detective said before she started the Miranda rights are coercive. She was in a room where she could not leave with 2 homicide detectives. One was wearing a firearm, and she acquiesced to authority based on an improper reading of Miranda. I wanted to file motions to that effect. We've got trial coming up October the 7th. I wanted to wait to get those policies. I wanted to wait to get the Miranda rights forms. The homicide detective actually reads it from a card. And I believe she read it incorrectly and she left out the main question at the end. So the proper thing to do is to get that information and make sure it's verified before you file in good faith a motion to suppress her statements. Well, the state attorney has tremendous power. I've made this request, September the 10th. Now it's, the 19th. And I'm in line with other public records requests there at the Orange County Sheriff's Department as to when I get this information. The state attorney could have gotten it the very next day if they would have made that request. That's why I filed the specific motion for the additional evidence. Time was of the essence. The court denied my motion on September 3rd to continue the case. We've got about 18 or 19 days left for trial. I'm still waiting. I've still got to receive that information. I've got to file the motion. I've got to set it for a hearing. I've got to subpoena the 2 detectives, the 2 homicide detectives. We've got to have a hearing with 18, 19 days left. I'm still waiting on this information from the sheriff. I've made a good faith attempt. Time is ticking. The state could get that information to me tomorrow. Thank you.
Response.
Your Honor, it's not Mr. Owens who's on trial, it's Sarah Boone.
Oh!
Sarah Boone was interviewed by the Orange County Sheriff's Office on February 24th and 25th of 2020. Now, some 4 years and 7 months later, there's this exigency not created by us, created by them. It's the defendant who has not done this for 4 years and 7 months. Now, turning to the merits of this, they are asking for discovery from a third party. Any discovery request, whether it is of the state or of a third party, has to involve allegations that this information is reasonably calculated to lead to admissible evidence or be pertinent to some analysis in this case. They have not stated why in their motion, and the arguments in court today do not state why it's pertinent either. The case law does not say statements are inadmissible or only used for impeachment if the law enforcement officer violates policy. There's no case law that says statements are inadmissible or only used for impeachment purposes if they don't read from their Miranda card properly. What the case law states is statements are inadmissible if there are Miranda violations and only used for impeachment, or if statements are involuntary, basically through promises, then they can't be used for any reason. But nowhere in this analysis does it matter to any degree what a standard issued Miranda rights card looks like or what their policy is on interviewing. What they do have and what the defendant has had since February or April or whenever discovery went out in 2020 was a videotape of these interviews. There has been absolutely nothing stopping anybody from filing a motion to suppress if they believed under the case law relief could be granted under the law. And the law does not have any analysis regarding standardized issued Miranda cards or policies of law enforcement agencies. And I don't believe that's admissible at trial either. If they did not violate the Constitution of the state of Florida or the United States in compelling an involuntary statement or by violating the dictates of Miranda versus Arizona, then questions about whether they read from their right standard card or if they violated policy should not be admitted in trial because it does not help the jury understand whether or not an element of the crime has been proven. It's not a part of the lengthy jury instruction now that we give about defendants' statements. There's nothing in there about, well, did they violate their Miranda card? Did they violate their policy? So first of all, the state's position is they have not asserted the materiality needed to get discovery ordered by this court, which would be reasonably calculated to lead to admissible evidence or to lead to it being found inadmissible by the court. And then secondly, it's on them to conduct this discovery, and coming in and saying that I can snap my fingers or not snap my fingers and get it for them instantly isn't evidence either. So it's our position that their request should be denied, primarily because it's immaterial, and then secondarily because it's on them. She's been aware of these statements since February 24th and February 25th of 2020. Thank you.
Thank you. Response to the materiality, please.
Judge, I believe the prosecutor is wrong. One of the jury instructions, standard jury instruction in criminal cases said that essentially a statement has been placed before you that's made by the defendant. And I don't have the language here, but it should be weighed with great care and caution to make sure it was freely and voluntarily made. These are some, but not all of the circumstances that you should consider in deciding whether or not the statement that was made by the defendant was freely and voluntarily made. If you decide that it was not freely and voluntarily made, that evidence should not be considered by you in this cause. So even if we filed the motion, we got the information, the additional discovery that we need in good faith for me to file it, if we received the information, I typed up the motion, we had a hearing, the two detectives testified, and the court ruled that the statements were not suppressible, I could still bring those facts into the trial of how the mistakes that were made by this lead detective in the coercive statements that she made, as well as not giving the full Miranda rights form and getting a full consent from my client, that goes into evidence for the jury to decide whether or not to consider the statement at all. Thank you.
So where's the violation of the Constitution then? Assuming you're correct and assuming that the Miranda card, something was missing, what's the issue?
It's coercive. The statements that the lead detective, the female detective makes, there's 2 or 3 statements she makes.
Now you have to understand, I'm in a vacuum here because I haven't watched the video. I'm not asking you to play it.
I probably should have.
But I need a little bit more context as to these statements because I have unfortunately no frame of reference.
But she says, number one, the date of this event, they seized her phone at the scene. She was told that they were going to bring her phone back to her, back at her apartment, the very next afternoon. The female detective called her, or Sarah called the female detective about the phone. The female detective said, I'm pregnant, I'm not feeling well, I don't want to drive out there to give you your phone. Would you please come to the sheriff's department so that we can give you your phone? Sarah Boone got there and saw that there was a desk or a place there to retrieve the items, and she saw the male detective and said, is this where I go to get the phone? He said, no, we got it back here in this room. Come back here in this room and we'll get it. When they walk back in there is when the video turns on, and now they're in the interrogation room. She's got a list. Sarah Boone has a list of things that she was wanting to ask them. And the female detective says, look, we got the autopsy back from the medical examiner. We've got to talk to you about that. 2 times she said, we must, I don't think it's must, we've got to talk to you. She goes, okay. So I got to read you these Miranda rights again. And again, she had read them. There was a statement that Sarah Boone gave. Of course, she gave a general statement to the first deputy that responded to the scene. She was wearing a body cam, so that deputy had called the 2 homicide detectives, but it took them a while to get there. So she asked Sarah Boone what had happened, and Sarah explained that situation. After the detectives got there, they took a general statement from Sarah, but at some point they got into one of the squad cars. And I believe it was Sarah Boone, I believe it was the female detective and the male detective, and she was read Miranda rights, again, incorrectly, and she gave a statement. So now the next day, she's back in the interrogation room with the 2 deputies, the 2 detectives, and the lead detective says, we've got to talk to you about this autopsy. Giving her the impression that's what they were going to talk about. But I've got to read you these Miranda rights. And she said something, and Sarah said, protocol? Because they had told her in the first Miranda rights that this is just protocol. We have to do this before we speak to you. And she said, yes, protocol. So based on those statements that we've got to talk. You have to talk to us. We've got the autopsy. Led Sarah to believe that they're going to talk about the autopsy. In addition, then she starts in the Miranda judge, she made a mistake on it. I don't know if it's an anonymous mistake, but in her probable cause statement, she said, I read the rights verbatim. The constitutional Miranda rights, I read to her verbatim. That is not true. Fortunately, we have it on audio. Fortunately, we have it on video. There is a legitimate question about whether that statement, that 2-hour interrogation, is admissible in this trial. That's what I'm going to show the court. I'd like to get their policy just to see.
What does the policy have to do if those statements were inadmissible? What does the policy have anything to do with that analysis?
To see if
because if you're saying you have a deposition, I'm assuming it's a deposition of the female detective, said I read it verbatim, and you're telling
that's in the probable cause statement.
That it was read verbatim. Okay,
yes,
excuse me.
Formulated the arrest report. It was a supplemental report or either the actual probable cause report.
And the representation in there is it was read verbatim.
That's correct.
Now, you've reviewed that interrogation. It's your position that it was not read verbatim. What does the policy have anything to do with that issue? I think that's a simple constitutional issue, right?
Yes.
If there's a case law that buttresses that position, and that de facto is a violation of the Constitution, ergo that confession or statements are not admissible because of the violation of the Constitution. What does the policy or the Miranda card have anything to do with anything if you have the video and the audio?
Well, the Miranda card is going to show that she actually omitted the last question. Okay? So the Miranda card is there for a reason. I don't know if they have them in the interrogation room or every deputy or homicide detective is issued that card, but it's a small card. But I believe it's going to say on there that you've got to get the waiver. There's 2 questions at the end, which is, did you understand the rights that I've just read to you? And the next question, understanding these rights, do you agree to speak with us now? That question was not read. It was omitted. I don't know why. She's sitting there reading it, and
Does the fact that that question was not read impact constitutionally under case law the admissibility of those statements?
I believe so. Along
That doesn't
with
answer
her
my
other 2
question.
statements.
Respectfully, that doesn't answer my question. I understand what your belief is, but where's the case law that you can provide to the court?
I'm not ready for that, Judge.
Okay.
I'm going to file a motion to suppress, and I'll supply you with the case law, but I'm not ready for that. But the reason I wanted the policy, getting back to your first question, is because I'm sure the policy is going to say you don't make any pre-Miranda statements like, we've got to talk. We've got to talk about this autopsy. Those type statements are improper, that they're used to coerce somebody to talk. And I understand the detective, they had these videos, the 2-minute video and the short second video, and they had found it on her phone. So the homicide detective was chewing at the bit to get her to talk. So she was trying to induce or influence her to speak to them and to not exercise a fundamental right, not to speak to them without a lawyer being present. So she made those 2 statements preliminarily that I believe the policy is going to say you don't do.
Okay. Mr. J, anything else, sir?
Just the Orange County Sheriff's Office doesn't set the policy for what is admissible evidence in court. The United States Supreme Court does, the Florida Supreme Court does, the 6 DCA courts do, and then ultimately, following their guidance, you will decide whether or not a statement is admissible in the state's case in chief, or if it's only available for impeachment. But whether or not, let's say hypothetically, she read the Miranda card 100% accurately, she followed policy 100% accurately, the state of Florida can't come in and say, Judge, I know they violated U.S. Supreme Court case law, but they followed the sheriff's office's policies, so these statements are clearly admissible. And the contrast is exactly the same. Whether or not they followed policy or read the Miranda card accurately has nothing to do with the analysis as to whether these statements are going to be admissible or only admissible for impeachment. And I don't believe that under the case law, they can come in if those statements are admissible and argue to the jury, they violated policy. They didn't review, they didn't read everything on their card. They violated. How does that help the jury decide whether or not the statement's voluntary? It doesn't matter what the policy is. It doesn't matter what the card is. What matters is whether or not they say the words that are required by the United States Supreme Court or the Florida Supreme Court or the 6 DCAs. That's what matters. That is what determines the bar for the admissibility in the case in chief or an impeachment.
Okay, thank you. All right, thank you both for your arguments and your positions. In reviewing the authority provided by the state, which the defense has conceded is taken is what it is. I think state versus right is the guiding light for the court here. 803 Southern 2nd 379. In reviewing that analysis, the defense has put forth an effort to do so. It's not up to the state to prove up anything for the defense. At this point in time, both motions for additional discovery are denied in accordance with State v. Wright. Moving now to the defense's motion to appoint forensic psychologist filed September 2, and defense's motion to appoint crime scene reconstructionist and death investigator filed September 2. I did receive JACS's response in that my judicial assistant confirmed that they are not asking to participate in this hearing. And we did confirm that earlier this week. Similar to the other motions that we've heard today, I have reviewed them. Mr. Owens, you may proceed with anything else, sir.
Judge, I have filed the amended motion for declaration of indigency and payment of due process cost.
I did see that, sir.
And then there are 3 motions. I don't know if you got the third one.
Are you referring to the motion to return property?
No, relating to cost. Relating to cost.
I don't know that I have. I'm just going by what the notice of hearing reflected. So no, I don't.
I filed a seconded notice of hearing. I don't know if you got that.
Was it forwarded to my office? Because if it wasn't, I don't know.
I'll
that I
have to
got it
ask
yet.
Margaret. I don't know.
Okay.
But I filed a second amended notice of hearing. Can I
Please.
give you my copy?
And Mr. J, have you seen that, sir?
Dog in the fight with the expert.
Understood. Thank you.
Judge, what I had done
Don't
was
see
I
a date
had,
on here, Counselor. When was this sent? The certificate of services contains no date.
it was filed this afternoon,
Okay.
this morning.
Okay. All right, what is the other motion related to cost, sir?
Well, there's one for the appointment of the forensic psychologist, Dr. Julie Harper, and it's non-pro-tunc. I'd like it to be retroactive to when I actually had to hire them. As you know, I came on the case late, August, I believe, August the 30th.
That's correct.
And then I asked Dr. Harper to go down and see Sarah Boone. Dr. Harper lives in Okaloosa County. And she came down to Orange County, I believe, the Thursday after we had the hearing on September the 3rd. I believe that's when the court denied my motion to continue. And so, as you know, we had to file the notice of intent to rely on battered spouse syndrome within 30 days prior to trial, which would have been that Saturday, I believe. So she went down, Dr. Harper went down and saw Sarah again. As you know, Dr. Harper had seen her several times early on in the case, back in 2020, maybe 2021. And so she had the most knowledge of, I believe, any of the experts that have evaluated Sarah Boone over the course of these 4.5 years. She was the one expert that had seen her the most. I asked her to go down again in the hopes that the court would appoint her. And she agreed. That was, I think, on a Thursday. She called me that morning, Friday morning, and said, yes, I do believe that she suffered from battered spouse syndrome at the time of this offense. Based on that, I filed the motion. But so she jumped ahead and did some work prematurely before she had been appointed. So I'm asking for those costs for her to do the earlier work, that be considered, as well as Dr. Berkland. Dr. Michael Berkland is a crime scene reconstructionist and death investigator, and I'm asking for the court to consider paying for his fees as well as his transportation costs, as I have for Dr. Harper, again, to be retroactively to the time I asked him to be in work on the case. And then the last,
When was that, you're asking non-pro-tunc to win on that? Also to the August 30th date of your notice of appearance?
if possible, yes. That's when I officially got on the case.
Now, as to the third motion for cost, I don't have a copy of that, unfortunately.
Can I approach?
Yes, please.
Judge, I mentioned this expert, Dr. Michael Brannon, in that hearing that I think we had on September the 3rd. He's a clinical psychologist. If you'll recall, I'd mentioned him. He had served as an expert in the Marsha Thompson Palm Beach County case.
I recall.
And so, as you know, he serves a different role as a clinical psychologist. Dr. Harper is serving as a forensic psychologist. And
do you know what JACS's opinion with regard to the motion to appoint clinical psychologist? Because the email that you attach as Exhibit A to that appears to be Mr. Lake's email regarding the other 2 motions regarding Dr. Harper and Dr. Berkland. And it doesn't address Dr. Brannon, and notably JACS isn't here.
I don't have an answer for that. Maybe we could table this.
I think the state has, I'm assuming, no dog in this fight, similarly as they had with the other 2.
The only request in this area that the state is going to make of the court is to, under its discretion under 3220, order these experts to produce written reports. We are on the eve of trial. I do not need one from Dr. Julie Harper. Her deposition is set October 1st. These two other people, I have absolutely no idea what they are going to say, and we would, I'll file a written motion and a proposed order and send it to opposing counsel. But that's what the state's request is going to be on the other two experts.
Yeah, I don't know if I'm going to have an objection to a written report or not. I may, but I'd like to see what the motion says before I make a decision. But yes, Judge, we have scheduled Dr. Julie Harper's deposition at her office in Okaloosa County on Tuesday, October the 1st at 10:30 a.m. Eastern Standard Time.
Is that in person or is that virtual?
Central?
Is that in person or is that virtual?
I believe it.
Okay.
The state's flying in, and I'm going to be there, Judge. That's the county over from me, Santa Rosa County. So about an hour drive for me. So I'll be there in person. We're going to have probably Kevin Beck that's going to appear by Zoom.
All right, so here's what we're going to do. JACS has provided their response, and their response was not appended to the motions that were filed because that was prior to the amended motion seeking indigent costs that you filed, Counselor, on behalf of Ms. Boone. I'm going to hand file with the court now the September 9th correspondence from JACS reflecting that that can be utilized in lieu of a formal response. I'm going to grant your motion to appoint a forensic psychologist dated September 2, 2024, non-protunct those costs to August 30, 2024. And with regard to the other motion, the motion to appoint crime scene reconstructionist and death investigator, I will also grant that and appoint Dr. Michael Berkland, non-protunct, to August 30, 2024. With regard to the motion to appoint clinical psychologist, when was this motion filed? Similarly, the certificate of service does not reflect a date.
Let us check real quick, Judge.
Sure.
Give me a minute.
Yeah, you're good. Excuse me.
No, Dr. Michael Brandon. It had to be filed.
They're like, oh, was that supposed to work? Like, what? I'm sorry, I was filing my nails. Sarah.
While you're waiting on that, I do see on your second amended notice of hearing, you also requested the amended motion for declaration of indigency and payments of due process costs also be heard. When was that motion filed as well, Mr. Owens?
Mr. Owens is not used to doing JAC work.
Prior to filing these amended ones, it had to be filed prior to my motions for appointment of these experts.
Give me a second. Okay, so the motion to appoint the clinical psychologist regarding Dr. Brannon, was filed yesterday. The amended motions regarding Dr. Berkland, an amended motion regarding Dr. Harper were filed yesterday, as was the amended motion for declaration of indigency and payment of due process costs. That motion has not yet been granted. It is going to be. So the amended motion for declaration of indigency and payment of due process costs is granted. The amended motions regarding Dr. Berkland and Dr. Harper are also granted non-protunct to August 30. With regard to the motion to appoint clinical psychologist filed 9/18, I'm going to ask Ms. Barrios, my judicial assistant, to forward that directly to Mr. Lake. And I know that she's watching this virtually. If she's able to do that now, I would greatly appreciate it, and see if we can get his response to that this afternoon. And maybe we'll be able to address that. It may be a similar vein as to the prior response that JACS had provided. Moving now to the motion for return of property, or in the alternative, motion for independent exam by the defense, filed September 18th. Similarly, with everything else, I've reviewed that and the authority, and I have reviewed the state's response to defendant's motion for return of property, or in the alternative, motion for independent exam by the defense. Mr. Owens, you may proceed, sir.
Judge, I believe the state's response is well taken. And I believe that what we need to do is get an expert of our own that can do the phone extraction and meet with the state attorney and the sheriff's department and extract the data, all the data that we need from her phone. So we would submit that the property should not be, based on the authority the state attorney has cited, the property should not be returned to the defendant since trial is still pending. But in the alternative, we're asking for an independent exam by the defense.
Response, if any?
As the state has stated in open court while she was pro se, that is absolutely fine. And I've even suggested a name.
Has the defense ever performed an evaluation of the phone? And the reason I ask is there were prior experts that were appointed in the realm of electronic evidence.
Mr. Cacciatore may have the answer to that question. I don't, but I know that the state, as I stated in my response, we've never prevented anybody from doing that. And as the homicide supervisor, everybody in the unit knows how to go about doing this and allowing a digital forensics examiner hired by a defendant to go and work with the law enforcement team and get another imaging if they are not satisfied with the imaging that has been provided.
Mr. Cacciatore, good afternoon, sir. Can you hear us? And if you can you announce your presence for the record, please?
There has not previously been a forensic exam of that phone by a previous defense counsel.
Okay, all right, thank you very much, sir. There was a John Sawicki that was appointed back in, not appointed, authorized back in 2020 as to electronic evidence. So I'm going to deny the motion for return of property based on the citations contained in the state's response. And I'll leave it up to you, Mr. Owens, to do what you need to do in order to have that review.
All right, I'm gonna do my best. We got about 18 days.
I'll cite to the parties for their own benefit. There were motions, specifically defendant's motion to appoint an electronic evidence expert and order the Justice Administrative Commission to pay costs. It was filed back on May 5, 2020. An amended motion was filed the next day, May 6th. Both of those cite to or refer to John Sawicki, S-A-W-I-C-K-I, electronic evidence expert. And there was a order entered back on August 3, 2020, appointing Mr. Sawicki as a forensic specialist. I have no idea if that order is still viable, but I'm just providing what the court file reflects in that regard. Lastly, that takes us to the notice of intent to rely on the defense of battered spouse syndrome. The original notice was filed September 6th. The state's original motion to strike was filed September 9.
Just to interrupt, I also have this defendant's motion for enlargement of time to address as well.
Yeah, I have that on my list, sir.
Okay.
Thank you. Thereafter, on the 15th, an amended notice of intent to rely on the defense of battered spouse syndrome was filed. On September 13th, the defense's response to the state's motion to strike defendant's notice of intent to rely on the defense of battered spouse syndrome was filed. And then I think it was this afternoon. Earlier today, the state's motion to strike defendant's amended notice of intent to rely on the defense of battered spouse syndrome was filed. The court has reviewed those and all of the citations contained therein. Mr. Owens, you may proceed, sir.
Judge, I wanted to start my argument, and then Mr. Henderson, who is on the screen, is going to respond to the state's pleading that they filed this afternoon.
Mr. J, you have any problem with that?
I know there's a rule in the circuit about one witness per one attorney. I don't know what the administrative rule says about arguments. I leave it to the discretion of the court.
Okay.
He's arguing that one motion that they filed this afternoon, that I've been working on these. He was working on that motion, so it's a separate motion.
The motion to strike.
The last motion whatever motion they filed today, Mr. Henderson, Tony Henderson here in the screen wants to respond to that. I'm going to respond to the ones that were filed prior to today.
All right, I'll allow it. All right, go ahead, sir.
Judge, as you know, I filed my notice of appearance on August the 30th, I think 38 days prior to trial, knowing that the court had already made a ruling that you would not grant a continuance unless there was some type of exceptional circumstance. And Sarah Boone hiring or retaining or somebody pro bono coming on the case and representing her did not constitute exceptional circumstance. And so, as you know, we had the hearing after I'd filed the notice on August 30th. We had the hearing on September 3rd on my motion to continue. The court denied it. At that time, I explained to the court that I believed after my meetings, I think I'd had 4 with Ms. Boone, that she met the criteria for battered woman syndrome, but that I needed an expert. And we were vetting several experts at the time, 4 or 5 that we were vetting, and we needed more time to essentially pick somebody to go out and do an evaluation, an assessment of Ms. Boone to determine whether or not they would give an opinion that she suffered from that. Because, and I understand, the court denied our motion, so that left us with, we still had to give notice to the state attorney 30 days prior to trial of October 7, which I believe was going to be September 7, which fell on a weekend, which was that Saturday, I believe. So we got out of the hearing. I think the hearing was on a Tuesday. We had 4 or 5 days to file this notice, timely file the notice. So looking at the file, I realized that Dr. Harper had the most time with Sarah Boone. Early on in the case, I think when Mr. Padilla was handling the case, she was appointed by the court to do an assessment and evaluation. And so I reached out to her, and she agreed to come down a couple of days after we had that hearing, and she met with and assessed Ms. Boone. I've retrieved all the notes, the prior notes, and then the notes from that meeting. And then on Friday, I spoke with her, that Friday, which I believe was the date that I filed this notice, September the 6th. That Friday, I spoke with her on the phone and immediately went down and filed the notice of intent to rely on the defense of battered spouse syndrome. We made allegations that Dr. Harper had formed the opinion that at the time of this offense, that Sarah Boone was suffering from battered spouse syndrome. And at that time, we gave the name of Dr. Julie Harper and her address where she could be found and located. Of course, the state has set her deposition for October 1. Now, the state has filed a motion to strike the notice of intent, alleging that we didn't give sufficient facts or evidence. But Judge realized at the time, I was simply trying to get it filed because the last day was the next day, Saturday. And of course, I had just gotten discovery. Judge Creighton, we have not finished reviewing all the discovery in this case. I pretty much shut my law practice down to try to do it. I've gotten my staff, and we're trying diligently to go through all the discovery. At the same time, we realize that we've got to establish corroboration of the battered spouse syndrome from eyewitnesses, from medical records, from potentially neighbors, court records, her phone and the information on her phone. So we're diligently trying, number one, to review all the discovery, which still has not been done. At the same time, trying to locate additional evidence that we could utilize in helping to establish the battered spouse syndrome. In addition, the state attorney yesterday filed a notice that they're amending their discovery, and all the jail phone calls, or I think they have the ability not only to call, but they have a tablet and they can text back and forth with third parties, that they have disclosed that they have, I guess, 4.5 years worth of communications between Sarah Boone and parties on the outside, and that some of that may be relevant to the case. And we were advised that when I got in town that I was to bring a CD, and I did this morning. I went to the state attorney's office and spoke with the secretary and explained to her that here's my CD, I'll wait. And I was willing to wait in the lobby to get this additional discovery when we have 19 days for trial. She told me that there was a lot, quite a bit of it, that she would try to get it to me after the hearing or by the time of the hearing. I said, okay. I left the CD. I told her she had my number. She could text me. I was staying at the Hilton across the street from the courthouse. As soon as she had it, I wanted it as soon as possible. A short time later, they have started, I guess, going through that material, and now they're sending discovery through email. I assume instead of the CD, they're going to do it that way. But we are receiving it. But just the volume of discovery that we have to begin with, we haven't gone through. The evidence we're trying to gather to corroborate our defense, and then additional discovery that we were noticed about yesterday. I didn't have time. I knew this had to be filed.
Well,
one more day. As soon as Dr. Harper told me on that Friday, I knew I had until Saturday. I filed it. The state knew. They've had it 4.5 years. They prosecuted the victim in this case, Jorge Torrez, at least 3 times. I think there's more like 4 or 5 times. But they opened up a file. They prosecuted him here in this county for battery in violating the conditions of bond relating to staying away from Sarah Boone, but battery on Sarah Boone. They, if anybody, was well aware that there was a potential problem with the habitual nature in which Mr. Torrez beat on my client. In addition, my client expressed in the interrogation, which I know the court hasn't seen, please look at the videotape, please look at my phone, please look at the videotape, please look at the photographs. I need my phone to show you he comes at me. It was ignored. They've had all this evidence. They had to be on notice that this was a potential issue. And the reason being is all the lawyers that have been through this have appointed different forensic psychologists to assess her. The prosecutor that's not here today, that was here on September 3rd, when I mentioned the problems that we were going to have, getting an expert this quickly to form an opinion, said, oh no, Judge, we're not prejudiced. We've already got an expert. We intend to rebut any said opinion by an expert that she suffers from battered spouse. We're ready to go. We've got our expert. Such that they said, we don't even need a continuance. If in fact he finds somebody and they file something, a notice of intent to rely on battered woman syndrome, within the time limits, we're ready to go. We don't need to continue it. We'll have our expert. And as you know, they're requesting that their expert now be allowed to go to the Orange County Jail and assess Ms. Boone, which they have every right to do, since we had filed this notice. But they indicated they would not be prejudiced. They indicated they were on notice. They didn't think it was going to happen 4.5 years, but it did. They knew all the prior abuse that Sarah Boone suffered at the hands of Mr. Torrez. I did the best I could, Judge. I filed it. I felt like I had to have an expert. I explained in general terms that she was psychologically and physically abused by Mr. Torrez repeatedly over a period of time that led to this event. They filed their objections, which we believe is misplaced. The court, as you know, by that rule, let me find it.
Please hold.
It's apparent not only that the state was on notice, that we were going to rely on it, it was prepared to respond, and was not prejudiced in any way. The notice of intent to rely on the defense of battered spouse syndrome comports with the requirements outlined in 3.201, given the current circumstances of the case. And as you know from that rule, it says the notice shall contain a statement of particulars showing the nature of the defense the defendant expects to prove and the names and addresses of the witnesses by whom the defendant expects to show battered spouse syndrome, insofar as possible. Insofar as possible. I did the best I could, Judge. In addition, as soon as we started going through the discovery and gathering information about the prior events, the prior arrest of Mr. Torrez, the prior prosecutions of Mr. Torrez, we immediately amended the notice on September the 15th of intent to rely on the defense of battered spouse. And again, listed as many witnesses as we could based on the good faith belief that we had that corroborated either by witness testimony or physical evidence, photographs, videotapes, medical record, whatever we could find that would corroborate our defense. In addition, we've listed the ex-husband, Brian Boone, and the last paragraph, paragraph 14 says the defendant's investigation of evidence to support the defense of battered women syndrome is ongoing. The defense anticipates additional witnesses, photographs, videotape, medical records, court records, and other evidence gathered from the defendant's phone will be forthcoming. This evidence will be disclosed as it is discovered.
Thank you. Response, sir.
Judge, the state is not surprised by any of the evidence that has been in the discovery for years. I'm not going to belabor the facts in the discovery, but suffice it to say that the decedent and the defendant had a violent relationship, and generally this violence seems to be fueled by alcohol. We're completely aware of all of this domestic violence history, but that does not make a battered spouse syndrome defense any more than being mentally ill without showing more makes for an insanity defense. Their original notice was insufficient, and there's no reason to argue it since they've amended it. So turning to the amended notice, it still does not set forth what they are going to show that shows that she suffered from battered spouse syndrome. Was the decedent isolating her from her family and friends? Was he telling her that if she ever leaves him, he'll kill her? We have these instances of violence between the two of them. And when we get referred to the ex-husband, Brian Boone's deposition and statement, what he reports is that Sarah Boone would attack him, scratch him, punch him, and that she was a habitual alcoholic.
And liar.
He would have to lay hands on her to restrain her. So we are going to potentially dive into all of this information in trial, but there are still the rules of evidence. And the cornerstone for the battered spouse syndrome defense, which is a misnomer under the case law because self-defense is defense, and battered spouse syndrome evidence is relevant to help a jury understand why it's objectively reasonable for a battered spouse to stay in a situation that puts them in fear of continued violence. The state and wherein our confusion lies is nowhere in any of the witnesses or any of the discovery that they have listed, exhibits that they don't even have been listed, medical records and so on and so forth. Nowhere does it set forth this cornerstone that is absolutely necessary before we get into any of this battered spouse syndrome evidence, before we get into any potential reputation for violence evidence of the victim, before we get into any potential specific acts of violence by the victim, before we get into the rebuttal evidence that is going to be offered against her for her violent nature and her drinking. The cornerstone is self-defense. Her statement to the police is not one of self-defense. It is one of accident. She repeatedly says there was no violence that day. So that is where the state's position is that their notice is deficient. It only sets forth that there has been violence between the two of them, and it's apparently exclusively alcohol related. But it doesn't go on to say this violence has caused her to suffer from the syndrome. And here's why. She was afraid to go meet with her family. She was afraid to leave. She was any of the things that make up what is actually battered spouse syndrome. And moreover, it doesn't set forth the self-defense claim, which is the cornerstone of this. None of this comes in without a claim of self-defense. And so that's in part why we filed our motion in limine with that response is the court can and should not allow any mention of battered spouse syndrome come in until self-defense has been established at trial. And as far as I can tell, the only person that can set forth a self-defense claim, since it was just her and the decedent in the apartment that night, is her. So she'll need to testify, and then she'll be impeached unless there's a ruling that the statements that she made to the Orange County Sheriff's Office are not only a violation of Miranda, but are involuntary and unavailable for impeachment use. That's what we're hoping to avoid, because we can't unring the bell during trial. If they put on all of this testimony and evidence about battered spouse syndrome and about the past violence, and then we introduce evidence about her past violence against him and against Mr. Boone, it's hard to unring that bell. And even though King versus State, a 2000, I forget which year, 19 case allows the state to point out the things that are promised in the defendant's opening statement, but then don't come to fruition, that doesn't unring the bell. So that's what we're asking for. We're asking for sufficient notice. The statement of particulars that is required by the rule, where is it setting forth there is a self-defense claim, and then there is going to be this shown beyond just the past violence between the two of them. Thank you.
Judge, they're scheduled to take the deposition of Dr. Harper October 1, so they're gonna know fairly quickly what her opinion is.
What's your response to Wagner?
We're going to talk about Wagner, Judge, and I don't want to talk about that in a minute, but he's bleeding the argument into state's motion to strike the defendant's amended notice. And I would like for Mr. Henderson to respond to what he said about that. But Judge.
Because I agree, there's two different issues here. The first issue is the sufficiency of the notice, and whether the notice is sufficient under the rule. The second issue from the court's perspective, is it applicable? And that's the hang up that I'm having.
That's not to be decided today. That's not Wagner, whether it's an accident or whether it's battered spouse and there was self-defense. That's not to be addressed today or not to be decided today. That's going to be based on the testimony from Ms. Boone about what was going on. But I'd like Mr. Henderson, if you don't,
but that's not what Wagner stands for. Wagner didn't allow, Wagner struck after multiple amendments, and the court, and we can take judicial notice of it if you want to, the court has pulled the file from the trial court in Wagner and has looked at the notices that were filed in that case for the battered spouse defense.
Judge, ultimately, the female defendant in that case claimed that the firearm discharged accidentally.
Correct.
And the court ruled, hey, you can't have it both ways. It can't be an accident and at the same time be intentional that you committed as self-defense because you're a battered spouse.
Right. So how is battered, even
it's premature for them to be arguing the question of intent.
But that's not what Wagner says. What Wagner specifically says, although the trial court found the third legally sufficient, the court granted the state's motion to strike the notice and precluded appellant from presenting the battered spouse syndrome evidence at trial. And the DCA says that the evidence underlying in that case was all accident. Specifically, the located.
I'm not doing that. I think it's long term.
Battered spouse syndrome as admissible where the defendant claims accident rather than self-defense.
We're not claiming accident.
Well, then what are you claiming?
Self-defense.
But every case that you cite, Medina, Hickman, its progeny, all pertain to some act by the accused. And that battered spouse is an excuse, a justification, an explanation for those actions. How is your purported defense applicable legally?
That's the reason we asked for the statement of particulars, Judge, so we could find out exactly what they were claiming that she did, what overt act or what omission. The overt act, was it zipping him into the suitcase?
But
Was that the overt
But
act
all of the-
that caused the
But
death?
all of the battered spouse syndrome cases talk about a defensive issue. Not meaning defense, your side of the ledger issue. I mean an action in defense. Wagner fired the gun. It was accidental. Hickman fired a gun. There was an act that was done by the victim or by the defendant in those cases. And battered spouse was used as an explanation for why it is that they did. How is that applicable to the case at
I
Boston?
assume they're going to say she overtly zipped him up in the suitcase. I assume they're going to say he was asking to be let out of the suitcase and she refused. She failed in a duty to act. Later on, she went upstairs and fell asleep. So it's either an act or an omission, but they're claiming an act or a series of acts led to the death of Mr. Torrez, which they have alleged was directly caused by Sarah Boone's actions or non-actions.
Kranick's done.
Yeah, this is not flying well with him.
He's whiny. He's needy. He's
Hickman, the defendant, stabbed the victim to death. And the justification was battered spouse. In Terry, which you provided to the court, Terry v. State, 467 Southern 2nd 761, it was firearm. What's the
mechanism?
What is it?
They're the only ones that can answer that, Judge. That's why we asked for the statement
I
of
don't
particulars.
understand that circular logic. And the reason I don't is because it's your defense.
Okay. I'm assuming that they're claiming that she zipped him up in the suitcase against his will, would not let him out of the suitcase, and therefore he suffocated. So the act of zipping him up and then the non-action of not letting him out when he asked to be let out constituted the offense of second-degree murder. That's the only explanation that we can come up with based on the report, based on the evidence we have. But Judge, you remember Marsha Thompson, the Palm Beach County case?
But there was a firearm.
There was a firearm.
She discharged a firearm.
Remember Dr. Brandon said on the issue of imminent threat, it is in the mind of the battered spouse woman.
Right there's the words. Imminent threat.
That's correct.
There was a threat. Now, I don't know all the cases. I don't know the facts and
We
circumstances
talked
of that
about
West
this.
Palm Beach case.
Gary.
I know snippets that you provided to me, but I haven't read any opinions on it. I don't know where it is on the DCA or appellate perspective, and trial court findings are not binding on another trial court. I mean, the case law is very, very clear on that.
Judge, the state doesn't know what happened the 2 minutes prior or the minutes leading up to, the time leading up to the 2-minute video. The state doesn't know what happened after the 2-minute video. Only Sarah Boone can testify to that. That's for her to testify to.
Florida, the appellant has not cited, nor is our research
Put her on the stand?
located. Any Florida case holding that evidence of battered spouse syndrome is admissible where the defendant claims accident rather than self-defense.
Who claims accident?
Are you claiming self-defense?
Yes.
Well, that's the first
Did
time
we
that I've
not
heard
have this
that.
conversation
Judge, I just
yesterday?
mentioned it a while ago.
The word self-defense never came out of your mouth.
Judge.
Words that you believe that the state's position is, what you believe that they're going to try to establish, that we don't know what happened before and after that video. The word self-defense have never been uttered this afternoon.
Judge, for the record, we're claiming self-defense. We're utilizing the battered spouse syndrome in conjunction with that defense.
Okay. Right.
Not accident, as they want to allege.
Okay. Does your compatriot want to provide response further? Okay. Mr. Henderson, good afternoon, sir. Can you hear us? If you can hear me, sir, you need to unmute yourself.
Can you hear me now, Judge?
I can, but I have some concerns because I'm getting reverb from you.
I am trying to talk you to now. Are you able to hear me better?
I am, but it's my
He had all that time to fix his
that we're
audio.
hearing back again through your microphone.
Turn that volume down.
All right, this may work.
Get the woman in the office to fix it. She probably knows what she's doing.
I was thinking the exact same thing.
I mean, come on.
Where's the paralegal? Let her
Mr.
come in there
Henderson,
and
we'll give
fix
this
it
a
up for
shot,
you.
sir. You can go ahead.
Yes, sir. Can you hear me now?
I can,
Oh
sir.
my God.
Is that better?
Yes, sir, it is.
Yes. Yes, Judge, I'd like to respond. And first, where I want to start is here. But just the self-defense, justifiable use of deadly force, justifiable use of non-deadly force. Those are defenses that do not require a notice at all. A defendant doesn't have to come in before trial and say that I am relying on self-defense. The standard is it's in the standard jury instructions, and before you can give that jury instruction, you have to have, and the cases are pretty clear, an indication or evidence. It's just a scintilla of evidence. That's what the cases say to get the instruction. There's no notice requirement in self-defense at all. Now, battered wife syndrome is not a defense in and of itself. There's no such thing as a defense there. It is a part of a jury instruction, and the part of the jury instruction and what it explains is when you get to the point when you're starting to talk about imminent danger, and that because of this syndrome, they would perceive an imminent danger different than someone else. Because what the self-defense instruction requires is that the jury place themselves in the position of the defendant. In those circumstances, at that point, that spouse knows to help explain those circumstances. So the first instruction that you have to get before you can even start talking about that spouse is this. You have to get the self-defense instruction. So, and that would be decided based on the evidence at trial. The defendant doesn't have to come in and say, I am claiming self-defense. This is self-defense. There's no rule or circumstance to that extent. But there has to be testimony of self-defense. Now, once there's testimony of the self-defense part of it, then the court can give that instruction. If they find it sufficient, the testimony can give that instruction as to self-defense. Where that spouse comes in and it goes into a series, you have to have self-defense or some type of evidence of abuse before you can get into the battered spouse. And this is how it should work. There could be the testimony of Ms. Boone. There could be testimony that's actually in the notice from officers who responded to calls and actually observed physical injuries on Ms. Boone. There could be testimony from others, neighbors, or other people who observed injuries or certain things to Ms. Boone. But once you get to the point where you significantly or sufficiently apply that there is a battery or domestic violence situation that is ongoing, then, and not before that point, can the expert come in and testify. So the stopgaps on this that are built into our system. First, there has to be some accountability or some evidence of self-defense. Secondly, there has to be some evidence that testimony becomes relevant, then the expert can testify about these are the symptoms that I observed, this is what I watched, this is where it came from, this was the interviews, this was reviewing other type of data and other types of things, and preparing their expert opinion. So after that point, Judge, when you get to that point, then it doesn't become a judicial act at that point in time. What it becomes a jury question. And it is up to the jury to decide. And what it does, and it doesn't say that that spouse is a defense. What it will talk about in the jury instruction is this is something that a battle will know. Under these circumstances, if you find it credible, that you can consider. And that's what it does. So we have at the beginning when we start talking about motions to strike, because if I think the case was Wagner, there wasn't any testimony there. Wagner's testimony was accident, and that had it. And I really put it. No one reviewed the ruling of that. That was the testimony. In this case, we do not have testimony. What we have is to say in this case, saying the discovery in this case don't get it. But that's not solved. These rulings have to be known better on the testimony of the preliminary report, either testimony itself, preliminary evidence.
Mr. Henderson, we're having a difficult time understanding you, sir.
I'm sorry, Judge. Is that better?
Maybe. Madam Court Reporter and I were having a little bit of difficulty hearing you at the end. You seem to be projecting away from where your microphone is.
Okay. Judge, my name's talking to me, but my name is hearing me better. Can you hear me better now?
Madam Court Reporter. We will do our best, sir. Keep going.
Yeah. So to break it into court landing, Judge, is simply this. And to the court, here's the evidence that permitted at trial. The court cannot make certain decisions. The court can't make a decision is justifiable use of non-deadly or justifiable use of deadly force is appropriate to give and to the evidence at trial. At that point in time, the court has to make a decision if, after evidence, if the expert's testimony is even relevant. So if there is any testimony to prove the relevancy or to show the relevancy of the expert's testimony, then the expert can't come up and talk about that as fast. Now, if you don't get the expert to talk about that as spouse and render an expert opinion, battered spouse is out the window. So then you're just on self-defense at that time. But that argument and that decision can only be made after the evidence is put in that trial. And that's all I have, Judge. Thank you.
Oh, that was
Mr.
painful.
J, any response?
That was horrible. Absolutely horrible.
It sounds like we're largely on the same page. The one point that I would strongly disagree with is that this evidence of battered spouse syndrome is relevant to the subjective belief of the victim or the defendant. That is not what evidence is used for. It's used to help a jury understand what an objectively reasonable person would do in those circumstances. And there's more cases that I have not cited because I didn't know that would be raised today, but they kicked out PTSD testimony just last year, I believe it's an Okendo, because it was going to the subjective beliefs of the defendant rather than helping the jury understand why an objectively reasonable person in a battered spouse syndrome would stay. With that notwithstanding, it appears we're on the same page that the jury should not be hearing anything about battered spouse until the predicates are laid. And from the state's position to help us prepare for trial, pleading should be sufficient. And it's still our position that the pleading was insufficient. the state is well aware of the past violence between the two of them, with her being the aggressor and the decedent being the aggressor. There's evidence of that all throughout the discovery. But what isn't present anywhere in the discovery, and what left the state at a lapse in understanding this defense in particular, was, did this violence cause her to suffer from battered spouse syndrome? And what is this evidence going to be? Was he isolating her? Was he keeping her away from family and friends? Was he psychologically breaking her down? Was he doing any of these things that are a component of the battered spouse syndrome? Because all we have is her statements, which are almost 100 pages long, to the sheriff's office, where she repeatedly says that night that nobody laid hands on one another. It was a great night. We were hanging out, drinking wine, doing puzzles, painting, dancing with the dog. And then, like everybody else, we were playing hide and seek. And he got into the suitcase, and I accidentally went to sleep. And then she's shown her video. But her statements are all that it's an accident and that there was never any claim of violence that day between the two of them. So that's wherein the state's confusion lies. And I don't know how we're going to go about this at trial, if the defendant's going to have to testify in a narrative form, if she's going to come in and testify 100% differently than how she gave statements to law enforcement. But that's where we're at, is we don't want this in front of the jury until all of the requirements are met. And as far as I know, the only person that can say that it was a justifiable use of force that night is her, because it was only her and the decedent in the home that night. And thus far, she has not made any statements about a justifiable use of force. And then our second complaint about the intent to rely on the syndrome, again, without repeating myself, is it just sets forth that there was past violence between the two of them, but no particulars about what actually makes up the rest of the syndrome. Thank you.
Any other final
Look at
questions?
They've hurt his head.
Rebuttal to the state's argument, either Mr. Owens or Mr. Henderson.
Just, I'll let Mr. Henderson go, but just as it relates to Ms. Boone's testimony, that's what jury trials are for.
Mr. Henderson, any further arguments, sir? You're muted. You will have to unmute yourself.
Oh, no more argument, Henderson. No, please, no. Please say no.
Mr. Henderson, you're still muted, sir.
Can you see me? Am I muted?
Oh my God. Yeah, we've been doing this for 4 years now. Come on.
He don't know how to use
Can you
Zoom.
hear me now? Loud and clear, sir. Any other additional argument?
Holy hell.
Yes, Judge. The state is going to have the opportunity to depose the expert, Ms. Harper, who can tie those things together. That's why we have experts who know about these things and who have the knowledge, who can tie these things together and tell why she's of the opinion that she was suffering from battered spouse at that time. The notice is simply to require to let them know that we're seeking this avenue, and here are the witnesses that we're using to seek the avenue. We don't have to list a specific number of witnesses. It's just the ones that we intend to use. And as Ms. Owens has told you, this is an ongoing process, and we'll probably be adding more. But that's all I have. Thank you.
All right. Thank you very much. The court is going to take the issue under advisement and provide a written order. I'll endeavor to do that by the end of the week. Last is the defendant's motion for enlargement of time filed September 17th. Mr. Jay, have you had the opportunity to review that?
Yes, Your Honor.
Okay. All right. Any problems with proceeding with that this afternoon?
No, Your Honor.
Okay. Very good. All right. I have reviewed that motion. Mr. Owens, you may proceed, sir.
Judge, I do have about 2 or 3 other issues that we need to address, but
Of course he does.
I've asked for some time. I think there was an order. I know there was an order that you had submitted to writing and that was filed with the clerk's file that indicated that you wanted some things from the defense and from the state by certain dates. And I think that's a typo on paragraph 3. I said August 17. That should be September 17 on paragraph 3, Judge, of my defendant's motion for enlargement of time.
It says September 5 on paragraph 3.
Are you looking at my defendant's motion for enlargement of time?
Yes, sir. Paragraph 3 says Dr. Julie Harper met with defendant Sarah Boone on Thursday, September 5, 2024. Am I looking at the wrong thing?
I'm sorry. I was looking at the wrong one. If you look at the second page.
Yes, sir.
Paragraph 7.
Yes.
That should be September 17th.
Yeah, got it.
Okay.
I mean, obviously the court's order, the August 5 order speaks for itself.
Judge, and as you know, we came in late. Dr. Harper formed an opinion that week. We filed a notice of intent to rely on battered spouse. It's ongoing. That's all I can say. We're working, we're doing everything we can to uncover evidence consistent with our defense. The problem is it's 4.5 years ago, and the apartment complex in Winter Park has changed hands. So we're trying to run down the employees. We're trying to run down the other tenants of the place. We're trying to run down medical records. That office manager is critical. We've taken her deposition, but we can't find her. Brandon, I think it's Moats, the neighbor that lived right next door to Miss Boone and Mr. Torrez, and they shared a wall, is a critical witness in the case. We're trying to locate him. As you know, 4.5 years, people move. So we need more time, is my point. We're doing everything we can. We're working diligently. Billy Lane, the investigator, is working diligently to try to gather the information I'm asking him to gather. Coupled with the fact that we've got this phone that we're going to be extracting, I'm in hopes of in a few days. And I know that the state had extracted the phone and given us a lot of the data from the phone, but Ms. Boone says it's incomplete. That's the reason we want our own expert to extract it, that will be able to assist us in establishing evidence and testimony that she is a battered spouse and was a battered spouse prior to this event. But because of that, Judge, we haven't had time to complete that. And as I said in my motion for enlargement of time, we're asking to be flexible on some time limits up to and during the week of the trial, because we're going to be working that entire trial. Like I said, there's 18 days until trial starts. It's going to be a 2-week trial. I don't know when some of this information is going to come, but I assume every other day we'll probably be amending the discovery, the reciprocal discovery, and amending the notice of intent to rely on insanity or rely on battered spouse if we find other evidence that corroborates that. So we're just asking the court, and I know there's a rule that specifically this rule 3.050 that allows for this request. Thank you.
Thank you very much. State, any response?
Certainly the state is not going to be okay with them conducting their investigation once jeopardy has been attached. That is completely unfair to the state. This is the defendant's trial, not Mr. Owen's trial. She has been on notice of these charges since February 25th of 2020. She has gone through countless attorneys here who did not pursue this battered spouse syndrome defense, even though they had consulted with Dr. Harper back in 2020. And I believe the crux of that issue is going to revolve around her having to testify in the form of a narrative given her prior statements. So the state opposes any enlargement in time. The defendant has been on notice and has had centuries probably of legal expertise at her disposal for the last 4 years. And there may come a point in time where the state has to request a continuance prior to trial, but if this enlargement is granted. But certainly, once jeopardy is attached, that's not the time to be doing discovery. She's had 4 years to do this, 4.5. Thank you.
Any other final arguments, Mr. Owens?
No, sir.
Okay.
Thank God.
I'm just rereading the rule. Give me a moment.
Okay, nobody else is allowed to come on Zoom unless they know how to use it and get a microphone.
Exactly. And that phone has already been extracted in the appropriate manner once. It's been analyzed by an expert already. And Sarah's crazy. She thinks there's stuff on there that there's not. And when you have a client sit in jail for years like that, they can convince themselves of anything. I've got them say they weren't there. That's not them on the video. They were not there.
Mr. Owens, as I stated when we had our hearing on September 3rd, at that point in time, the court had outlined the history of the case, the court's prior findings, the numerous experts that had been retained throughout this case. And I understand the position that you find yourselves in. But at the same token, based on the same analysis that the court had relied upon in its oral pronouncement in denying your continuance on September the 3rd, I'm going to grant your motion and deny your motion in part. With regard to the filing of objections to the state's exhibits, by your own statement, you're still in the process of going through those. The deadline expired on September 17th.
Yep.
So I believe that we're using the second portion of the rule with regard to that issue because there's a requirement to provide those names, and this motion was filed on the 17th. So I'm going to grant your motion in part with regard to filing objections for the state's exhibits. I will give you up until the time that we're having our trial case management on September 26th to file any additional objections to any of the state's exhibits. With regard, however, to the filing of a witness and exhibit list, I agree with the state. We can't be amending once jeopardy attaches to provide additional experts or any witnesses at that point in time.
You're talking about jeopardy when the jury is sworn?
Correct.
On that Monday, October 7th?
If we're lucky enough to get one on Monday.
So
just so that you understand, I've ordered a couple hundred people for that week because I don't know how long jury selection is going to take.
Yep.
I don't know what people know about this case. So my intention is to run 50 people in the morning. So I'm just letting y'all full disclosure here, what my thoughts are. 50 people in the morning, get rid of language, get rid of cause. And if those persons who don't know anything about this case, I'm going to ask them to come back either Tuesday or Wednesday. And then we're going to run another 50 at 1:30. Get rid of our cause challenges, those who can't be here for 2 weeks, those who've just recently given birth, all the statutory cause reasons that they can't be here. I'm going to ask them to come back. And if we've got 40 people, 50 people at the end of Monday, we'll start Tuesday and we'll start whittling it down. And I can turn over when I'm done with my colloquy, my voir dire is about an hour and a half, 2 hours. And then I'll turn it over to the state and I'll turn it over to you and we can whittle it down from there. But if it takes us more time to get a sufficient panel because of the amount of time and other causes or preconceived notions about this case that can't be set aside, we may not be picking a final jury until Wednesday in this case.
Is this set for 2 or 3 weeks?
2 weeks. 2 weeks.
Yep. I told you, Sam.
Now, it was originally set for 3 weeks. And then when we talked about it, when you came on board, we had shrunk that to 2. Now, if we think that that may change,
or did you
I'd rather discuss that now than a week from now.
We talked about
3
it.
weeks, I can try my best to make that happen. But I respectfully need to know that sooner rather than later.
He thought he was going to get legal.
I did not anticipate. I anticipated we were going to be able to pick a jury in one day.
I would love to be that bullish.
Yeah.
I hope we can. I'd love to be able to. I'm just telling you what I've been working with jury services, that I've got 50 people teed up for 9 a.m. I got 50 people teed up for 1:30. And that will continue throughout the week. It's easier for me to say, we don't need you, go home. You don't need to show up for jury service, than it is, I need bodies and we don't have them.
Yep.
Now, if we're able to get a jury in one day, fabulous.
And you just got cranicked.
I have that backup.
I believe if we pick the jury in one day, we could try the case in 2 weeks. But if it's going to take a little bit longer, and again, we don't know from now until October 7th what other evidence or what other witnesses we're going to uncover. So in the abundance of caution, I'm going to ask the court, if possible, to set 3 weeks. I don't think it's going to take 3 weeks, but I don't know how long jury selection is going to be. I don't know what additional evidence we're going to uncover, additional witnesses from now until October 7th. So to be on the safe side, I would ask for 3.
Okay. All right. I'll see what I can do there, and I'll have Anita report back to both of you.
Judge, and the main reason, I think all these other lawyers, they didn't have an expert that had tendered that opinion about her spouse. So we started on this path on that Friday when Dr. Harper called me and I filed the notice of intent to seek corroborative evidence, corroborative witnesses that she was battered. So that didn't really start until that day, which was September 6th. And that's why, and again, this was an event that occurred 4.5 years ago, trying to locate witnesses. It's just taking time. I understand about the jury being sworn and we shouldn't be allowed to ask additional witnesses to come in. So I agree with the state on that. I agree with the court. But I would ask up until the time we pick the jury that we be allowed to amend reciprocal discovery and amend our notice of intent to add additional witnesses and additional evidence.
Mr. J, any other further positions, sir?
There just may come a point in time, Judge, if you don't set a deadline, that the state has to ask for continuance.
The deadline is going to be for objections to the state's evidence, providing of a witness and exhibit list for the defense at trial case management next week, September 26th at 9 a.m. In addition to all the reasons that the court placed on the record on September 3rd during the motion to continue. My JA has advised that Mr. Lake has appeared virtually with regard to the motion.
Oh boy,
of the
Christian Lake.
psychologist. Mr. Lake, can you hear me?
Oh, good. They're going to be able to get that out of the way.
Yes, I can, Your Honor.
Can I get your appearance for the record, please?
Yes, Christian Lake on behalf of the Justice Administrative Commission.
All right, thank you, sir. Earlier today, before your participation, I know that Mr. Owens had provided you certain cost motions regarding the forensic psychologist, Dr. Harper, and the crime scene investigator, Dr. Berkland. You had advised as the JACS's positions on those motions. Your email has been filed in the court file. Subsequent to that, a motion to appoint clinical psychologist regarding Dr. Michael Brannon was filed. That was just filed yesterday. I know my judicial assistant sent you a copy of it. Have you had the opportunity to review that motion? And if so, what is JCS's position?
Your Honor, just briefly, we did review the motion. Although we're not contesting it beyond objecting, we do object to any rate in excess of the rates established by law, but we acknowledge for this type of expert that it would not be uncommon to approve a rate of $200 an hour. It's if that does exceed the rates established for this circuit.
Mr. Lake, I hate to interrupt you, sir. Madam Court Reporter's having a difficult time hearing you. If you could start over and slow down just a smidge for us, we would greatly appreciate it.
Not a problem, Your Honor. We did review the motion to appoint the expert. Just to give the court some background, because I went back and looked through our files. So far, the defense has incurred, this is prior to Mr. Owens' involvement, but so far the defense had previously incurred $7,500 for one mental health expert, and that's the same mental health expert as being, not this expert, but was the other expert being requested, was requested by the defense in the other two motions. The defense also incurred $1,800 for a mental health expert that was hired by Ms. Cashman. That was, let me just get the right name, I don't want to say the wrong name, but she was paid $1,800. She was retained in relation to the issue that was before the court today, the battered spouse syndrome. And now the defense is requesting a third mental health, but also at the rate of $200 an hour. Based on the nature of the case, Your Honor, we have no real, other than objecting to the rate because it does exceed for the circuit, we don't have any other concerns about the appointment of the expert. It would be the third mental health expert appointed to assist the defense. But that really, I mean, ultimately that's your call whether to allow the defense to incur costs for a third mental health expert.
The motion reflects the rate as $200 per hour. Is that in excess of the ACS rate?
Your Honor, it's in excess of the rates for the circuit. Those were the rates that were adopted back in by the old Immigrant Services Committee back in 2007. We essentially generally don't ask for a hearing unless the rate is over $200 an hour. So we generally, again, we acknowledge that is, the rates generally range for mental health experts range between $150 to $200 an hour. So we don't particularly object to them. As far as what the rates were at that time, they are posted on our website, and I'm pulling them up right now because for the Ninth Circuit, the rates for medical doctors and psychologists are $160 an hour for out-of-court services and $178 an hour for in-court services.
State anything further?
Nothing on this.
Okay, all right. The court is going to grant the motion to appoint Dr. Brannon. I know that the state advised that this is not going to be nunc pro tunc. Because I've received nothing from you, Mr. Owens, that he's done any work yet.
That's correct.
Okay, so this will be effective as of today, the 17th of February.
September.
Yeah, is that not what I just said? I'm sorry if I did. Said a different date.
Mark.
I will take it under advisement the issues pertaining to the battered spouse syndrome and provide a written order. You had advised there were some other issues that you wanted to bring up, sir.
Well, he has more issues. He's got more issues than a damn People magazine.
This is interesting. I expected it to be different,
Relates to the
but not this
investigator
different.
Billy Lane, who's working with the defense, and his potential costs up to the trial.
Are these being hand filed now?
Mr. Lane handed them to me right before we came in, so I'm going to have to scan these in and file them.
Okay.
I wanted the court to be aware. If you want to address it at the September 26th case management conference, we can do it then.
Let's do that. Just do me a favor if you could, sir. Once they're filed, just forward them to Ms. Barrios.
Okay.
So that I've got hard copies of them.
All right, I'll
give these back to you, sir.
Judge, the other thing was, of course, we've got trial coming up quickly, and generally, when in a courtroom, I do opening statement, I maybe have some demonstrative aids, but I walk around, and I understand
Lord.
here that we've got to be in front of a microphone. Is there any way we can set up, maybe the defense can set up a system where we can wear a mic so that we can walk to some degree?
I will have to check with court admin.
All right. And then the other thing is,
Somebody call
we would
court
like
admin
Sarah
speakers.
to
Speakers.
wear
Fix
street
their
clothes.
speakers.
Street clothes.
So do
That's
do
normal,
need
so I don't know why they're
I
asking
have,
that.
get in touch with the public defender's office. When Ms. Boone was representing herself, I had coordinated and communicated with the public defender's office multiple times. in an
Judges
attempt
normally
to
don't do
obtain
this.
Clothing. Before you came on board, Mr. Owens, Barry Click, BARRIECLICK, had provided the total amount of clothing that they had that would fit Ms. Boone, including shirts, pants, slacks, skirts. And that was the time where she would be allowed free reign and was going to have the shock device on her lower leg. I would ask that you can email Ms. Click. You can find her information on the Florida Bar webpage and ask her if the public defender would assist you in providing clothing. They were going to while Ms. Boone was representing herself, and I imagine that offer would still be extended.
Judge, and I anticipate 2 more pretrial hearings. One is the case management conference, and 2, if I file the motion to suppress the statement made during the interrogation, we would probably have to set a separate date. Can she wear street clothes at those 2 hearings?
If you could get it to her.
Okay.
So that's something
Oh.
you have to work with corrections. I don't know that they're going to let
Why
you
does she need
do
them?
that.
Now, when it comes time to trial,
usually just for the jury.
She would like for us to have some makeup for her and
Oh,
somebody
for fuck's
to fix her hair. And
Oh.
it's presentable to the jury that she would like to be presented.
Can we get
Do
a
I
be-
need to file a motion on that? Or
I think you're going to have to.
We gotta stop talking.
I believe that's all I have, Judge.
Okay, all right. Anything else, State, we need to address? All right, anything else, Mr. Owens, or from your co-counsel?
No, Judge.
Okay, I will see you all on September 26th at 9 o'clock in the morning, and I will endeavor to get you a ruling on the battered spouse issue as soon as practical, hopefully by tomorrow.
Oh
All
my
right, thank you all very
God.
much. We're off the record.
Y'all, I have a headache.
Oh my God, I'm dying. I want to talk so bad.
Lord. Oh my God. Okay.
The
Wow.
whole thing about, can we get a hairdresser? I need a headset. He wants to
need
be up
hair
there
and
like
makeup.
Brittany and yeah, he wants to be up there like Brittany and Janet. Be like, Owens, bitch. You know,
Oh my God.
just call me Jamie, bitch. What? And then the whole her makeup and her hair. I'm sorry, that was just
So-
the last part, so I had to go there. Glamour shots. Get
Yeah, I haven't taken a female to trial, I don't think ever, which is odd. So I've never had to deal with a hair and makeup issue, but we always do provide clothes, or we ask the family to provide clothes if there is a family. And like I think I've mentioned before, the legs remain shackled. This is the first time hearing about these stun cuffs. But the jury never sees the defendants doing anything other than standing or sitting. So they never see that she's got leg cuffs on.
Yeah.
And street clothes for in front of the jury is normal. And then if they're convicted, like you see them come back for sentencing and they're wearing their jail uniform. I have not personally seen where there are street clothes for pretrial conferences.
I'm telling you, the chat is just going off right now. I mean, and this is just not even has nothing to do with anything. And I apologize, but I have to.
I'm seeing it.
I have to get this moment. Okay, I need this moment. I get makeup. Somebody said she wants a glamour shot. Wait, going for the hooker look. Let's get her the family jewels. She wants to control and look hot. Plastic surgeon. Laura says, I got scissors. Can't wait to read the forthcoming motion for makeup. Michelle says, check for staples. And Hartley, I think that's probably one of my favorite comments. Hamlet hair.
Oh, wow.
I'm sorry. I know you like to talk about the legal stuff, Sam, but sometimes I just have to laugh. I really laugh a lot on this.
It's crazy. I'm just sort of trying to process everything that just happened.
Am I too loud? Wait. I am too. Rosa, I wish Carrie's volume levels were nearer the courts. Am I too loud? I do have a tendency to be loud. I'll pull my mic away a little bit. I'm sorry, Sam. Okay. I'm not done with my jokes. I got one more joke.
Okay,
Go
ahead.
I'm sorry.
No, you're good.
I just noticed that the judge's clerk's name was Anita. And I can't help but jump off on this and say, Kranick, Anita, a drink.
Oh, man.
It's really not that funny. But yeah, I've been serious for the last hour and a half listening to this, so I had to let go. So I'm going to turn it over to you and let you talk about this stuff.
Really? Okay, so I was trying to take notes and I stopped at some point. So I'm going to give a plug for the videos or video that we did where we were addressing the cases for battered spouse syndrome. So for anybody that wants further explanation on that, I would direct you there because Carrie's got all the cases and everything, and we talk about it all there. As for Mr. Owens, what I have learned from working in Florida courts is that attorneys become very at home in their home courts with their home judges in their home courtrooms. There is sometimes no protocol. And when an out of county attorney or an out of circuit attorney comes, they try their old normal tricks and they don't work. And that's what Owens just walked into. He didn't get his good old boy club of judgeship going on here.
Yeah, I kind of it was so obvious that he's used to getting his, like, maybe he has a decent reputation where he's from. He just comes across to me as freaking sleazy. He's like, there are good defense attorneys out there. This guy right here is going to just, we're going to have to take a shower after every day of watching this trial, you guys.
It's going to be a 3-ring circus, but what has not happened yet is the judge has not said he's going to accept the battered spouses syndrome. So, yeah. Interesting capture says, Sam, your notes should be easy. No, nice try. Nope. I did sort of give up. Let me see if I can provide anything of worth here. Does anybody in the chat, are there specific questions? I don't want to go on about stuff that nobody cares about.
Yeah, let's just. There were some good questions in the chat. I should have been starring them as we were going. Hang on. All right, if you have a question, put it in all caps so that we can find it easily. Yeah, they're like, the next motion will be we need a bottle of wine for Boone. You're absolutely right. Well, you said Amy said Jaeger, but it's for Boone. It's going to be either Dr. Pepper and vodka or a bottle of wine.
Is he outside the courthouse giving a press conference yet?
I've got it on a live to wait. I've got a thing pulled up here, just looking. Yeah, Shannon's. She's probably. You guys, when he was sitting there on that bad. By the way, I love the picture of your dog. When he was sitting on that bad volume on the Zoom, the Henderson guy, I was thinking to myself, in her head, she is writing a letter. She is so writing that letter in her head, getting ready to fuss at them.
Mm-hmm. Yep. That was, I mean, I'm sort of, I have to say, I did not see James Owens and the Three Ring Circus coming. I just didn't, I'm kind of stuck on, oh my God. Do you think that he's also setting up for an appeal? Always, 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 always.
I think I saw it coming when he took that first interview. I was like, oh, and then when he went on Biddy Politan, I was like, yep, he's in it for he wants to be seen.
And he's gonna be. Okay. Carrie, do you want to start putting some of these?
Okay, sorry. I'm trying to push the thing
or
too.
Is your chat on slow mode?
Well, I guess it doesn't matter. I can go back and play it. Let's go. No, I've never had to worry about that. So she wants her hair and makeup done. JS, that's not a question. Why is it? Why is the defense cite? Why the defense cite the jury
instructions instead of case law? Because they weren't prepared or they didn't have anything that was backing up what they were asking for.
Okay, yeah, you're gonna have to answer these quick. Okay, is she going for BSS? Then why did she allow her son to stay in the house?
That's exactly. That's what the state's getting at, is that all of these sort of factors that develop around a battered spouse syndrome, the isolation, the controlling, everything we looked at in Marsha Thompson's case, when we looked at that the other day, it's all of those things. Sarah does not have those things, and that's what the state is saying. Matthew Whitehair on the appeal. So any good defense attorney is always laying down objections on the record, sometimes repeatedly, because of appellate purposes and because they can have ineffective assistance of counsel motions filed against them. Another Boone versus Owens screaming match in the jail looks. I don't know. I think it's too late for a plea deal. I think the state's had it and they'll push it to trial just because Owens is trying not to push it to trial. Can they battered spouse and mutual combat? No, not really. Owens is trying to paint it as though I've lost his name.
Henderson?
George. No, George. Like that scrambled my brain so bad. So the judge can rule against battered abuse. Yes, so it's what's called an affirmative defense. So I'm gonna bore people if I go on with this.
Don't get too deep. You'll lose them if you go too deep. Just
I know.
surface level.
So okay, normally in a trial, the state has the burden to prove every element of the crime charged beyond a reasonable doubt. It's their burden. The defense has to do nothing, and they try to poke holes, and poking holes leads to reasonable doubt. For this kind of a defense is called an affirmative defense, which means that at some point the burden is going to shift to the defendant to prove that she was a battered spouse.
And when I said we were going to lose, I didn't mean that. I wasn't putting y'all down. I'm just saying it gets too much. There's too much. Sorry. The legality of the interrogation. Thoughts?
Okay, that's where I thought they were going this whole entire time. I knew he was going to go there. I couldn't put my finger on what. From what the judge is saying, I believe he'll keep it in.
Let them do it. They're just,
If they're
it's a
getting in trouble
stupid
for
defense.
lying in interrogation that it was an accident but was well, I mean, you get in trouble for lying. I mean, she's charged with second-degree murder. So, and it's on record saying over and over and over again, it wasn't intentional. It wasn't intentional. So I'm not sure I understand that question.
Sam and Luis are both asking about the battered spouse. Luis is first asking, the judge can deny her that. Okay.
Well, because like in Marsha Thompson's case, they were able to demonstrate all these different factors here. And we were talking about this as we were watching the testimony there. It's so different. We don't have any of those factors. And it's so can the judge deny it's like I said, it's an affirmative defense. Can the judge deny that? I guess what he says is that the foundation for it's not there. Versus ruling against it. I don't know how to phrase that very well. But yeah, she doesn't meet the criteria. That's correct. PI have chances he will accept battered spouse. Not at this rate. He's not going to. Not at this rate. And yeah, exactly, Cage and Nana. Where Harper wouldn't do it before. So what's changed? Exactly. Yeah, exactly.
Wait, where did it say she wouldn't do it before?
So Cage and Nana says, why did Harper change her mind? Didn't she deny the battered spouse syndrome before?
I don't think she did.
I believe you are correct. She refused to. I think that's why she left, is because she wouldn't go down that road.
I didn't think she left. I thought that Padilla got pulled off of it.
Padilla walked off of it.
Well, you know what I mean. I thought I thought that it was just she was no longer involved because he wasn't no longer involved.
No, because your experts travel with the case. Even if a lawyer leaves, that doesn't mean that the expert has to leave. So yeah, that's a really, really good question, and I do have questions. Is he putting his response in writing? Everything will be in writing. West Coast. I don't even know what the rest of that says.
Yeah, we gotta go. Y'all might as well plan. Poor Judge Cragnack, bless his ever living heart. Y'all are gonna have to plan for this 26th thing to be very long. We're gonna be sitting here for a couple hours, I bet.
Yeah, we're gonna need like protein powder and caffeine.
I'm gonna start serving alcohol and hot dogs. Like
why is she allowed to doctor shop? I don't know that she's doctor shopping. It seems to me like the death investigator is different. They're looking for, one's a psychologist, I need to look them all up and list out their different specialties. I got some of them. I didn't get all of it. How would they use was Dr. Brandon on court TV giving an opinion? That would be a problem.
Oh, by the way, I wanted to show Leah that. Let me pull that up real quick.
Did we decide if we're pronouncing people's names correctly?
What are you talking about? I always mispronounce everybody's name. They're used to it from me now. And they don't take offense to it, I don't think, anymore. We're not going to watch this. I just wanted to show you guys. This is him right here. And he did testify in Marsha Thompson's trial. And I want to find that piece so we can see what he said in that trial.
I'm so mad they didn't televise that whole trial.
It's hard to find. Yeah, it's hard to find the coverage on it. So, but we'll see what we can find. Maybe somebody has something.
Yeah.
But I haven't done a deep dive on this guy yet. But I was trying to do
so
a deep
we
dive
do
on
have
Berkland.
a number of experts. And again, I'm going to just refer to the video that Carrie and I made. I don't even know what day it was. Was it yesterday? When did we do the video on Marsha Thompson and battered spouse? We did a video, guys.
Yeah, night before last. It went up yesterday.
Yeah, go check that out. It might explain some things that we're talking about.
Do you feel like you got oh my gosh, y'all, the chat's moving so fast. I can't even keep up.
It's slower on my screen. I don't know why, but
yeah, that's our new saying, you guys. Thank you, Nano. That's our new saying. Don't forget to hit the You got cranicked.
But don't forget to hit the like button either.
But don't forget to hit the like button. Gavel
And-
that button.
And to see all of the extra stuff that I piled on Carrie about Marsha Thompson's case and all the case law related to this case, buy Carrie a coffee.
Oh, yeah, I'm going to be doing some reading. And when y'all know if I have to do some reading, there's going to be some editing.
I gave you highlighted things.
Did you
That's helpful.
reference her? Did we answer Fan Lady's question? By the way, Fan
no.
Lady, thank you for all your super chats today.
Let me see.
Thank
Will
you, Mark,
the
for
defense use
yours.
new experts to ask for? Yeah, no, the judge has made it really, 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 really clear there's not going to be a continuance here. And what they'll do is they'll just turn around and try to raise it as an issue on appeal if it's an appealable issue, which I'm not sure it is. That this judge has done his homework and then some. So I don't see a continuance coming, not from him. So
Patty, you're my friend, and this is why we friends. Because we think so much alike. Y'all, I think the woman thinks she's gonna get to go to the spa before. Like you're not getting married, Sarah.
I know this is like her Cinderella moment.
Oh my God. Because you know what her thought process is? I'm going to be on TV.
I know. Because and whoever she's talking to on the outside will know how much this case has blown up in the last few days or the last week.
Yeah. This is freaking crazy. You don't believe how many people were just live streaming the trial. Because when I went over here and I clicked the live stream button to see if he was out on the courtroom steps doing his show again, I had all these people pop up that were streaming the trial. And I'm like, holy crap.
Yeah. Michelle. Okay. So normally they can have like nice dress clothes if somebody will provide them. Like I said a few minutes ago, I haven't had a woman go to trial. I don't think ever in my cases. I have almost all male clients. So I've never heard about asking for makeup and hair. Civilian clothes, yes, that's what happens in front of the jury. Civilian clothes, they are either brought by a family friend. Sometimes a family member will go to the Goodwill and buy things. Sometimes the public defender will have something that they'll loan out. In my last trial, one of the young men didn't have any clothes, and his attorney went to the public defender and came back with a suit that fit him, which was amazing.
Thank you, Kathy. Okay. Y'all know I don't like to incite riots, but I'm just saying that if you like to do hair or nails and you're in the Orlando area, you could put in a request to get into the jail, but I'm going to have to mic you up first.
Yeah, good luck with getting into that jail.
I know.
They wouldn't let the
you at the
take his computer.
I'm going to send Sam over there to meet y'all to get y'all in.
Mm-mm.
And I'm going to need you to wear a mic.
They wouldn't let the attorney in with his computer, which is just insane.
That is insane. Yeah, no doubt. Thank you for, of course she thinks she's going to the spa. Oh my gosh, you guys. Jeez, my knees. Beach. And you know what the funny thing is she walked around like no bra, no makeup, her hair just flying all over the place the majority of the time.
Mm-hmm.
And yet she wants to all of a sudden fix her hair, nail, and makeup. I don't know if I don't know that was probably something that he's put in her head. I feel like
I don't know where she got that from. Will her civilian clothes be sent in a suitcase?
Oh my gosh. Was that Mark?
No, it's JB Behemoth.
JB. I kind of think that I kind of wonder if her lawyer's not behind that statement. I think I'm telling you, there's something about this is like
Michelle
this guy acts like he's on Broadway or something. I don't know.
Yeah, he really does. He's performing. Michelle's saying there was a state's motion today.
That's what we read earlier.
Oh, okay. Okay.
Oh, here, let me go ahead. Let's check one more time for this live. Now, if they go live on the courtroom steps to interview Sir Talks a Lot, Jamie, I will, I'll just pause it and we'll come back and watch it. For now, I want you guys to see this video that we've done further on this Dr. Brannon. It blows my mind that he's still wanting to bring somebody like this in when he knows that his credibility is going to get called on the carpet.
Summa cum laude BSN. The trials are public. A trial like this, where it's possible the public will line up, then the courthouse is going to crack down on things. And I'm assuming that's why I'm curious to see if they move it to a bigger courtroom. There will, from how the judge is describing what he's already planned for the jury pool, I'm guessing that they're already talking about security at this courthouse, and that it will be televised will probably stand for people not getting in to see it in person, which is one reason why I'm not going there. I don't need to participate in that circus.
I guarantee you they're going back to what did we do when Casey Anthony was in trial. And they're thinking about how they can, what they're going to, the procedures and stuff.
Yeah, it's going to get a lot of, I mean, obviously it's already getting a lot of press. But yes, normally state courts are open to the public.
Okay, I'm going to play this video now.
Oh, sorry.
We are going to revisit the issues relating around Dr. Michael Berkland, who Sarah Boone's defense would like to bring in as their crime scene reconstructionist. September 10th of 2012, the following article was published by CBS News. Dr. Michael Berkland, former medical examiner, arrested for storing human body parts in Florida storage unit. Police arrested former medical examiner Michael Berkland on Friday for allegedly keeping crudely preserved human remains in a rented storage unit in Florida last month. Berkland, who is 57 years old, was charged with improper storage of hazardous waste, keeping a public nuisance, and driving with a suspended license. He was released on $10,000 bail. State Attorney Bill Edens said more charges may be filed. Berkland's attorney, Eric Stevenson, reportedly said that he and Berkland will start preparing their defense next week. Crudely preserved remains, brains, hearts, lungs, and other organs and specimens were discovered in more than 100 containers last month in a Pensacola storage unit that Berkland rented for about 3 years. The unit was auctioned off after Berkland defaulted on his payments, according to an arrest affidavit. 10 cardboard boxes stacked in a corner of the unit contained numerous individual containers with human remains stored in a liquid substance, according to the affidavit. Berkland declared the contents to be household goods, furniture, boxes, sporting goods, and landscaping equipment. A man who bought the unit's contents discovered the human organs after becoming overwhelmed by a strange smell while sifting through the items. Most of the containers were labeled. About half of the containers were medical grade, and the other half included soda cups and plastic food containers, according to the affidavit. Authorities said the organs were stored in a liquid solution containing formaldehyde and methyl alcohol. The remains included tissue samples and dissected organs. Investigators also advised that there were numerous whole organs, including heart, brains, and liver and lungs. Berkland worked at the District 1 Medical Examiner's Office in Pensacola, Florida from 1997. He was fired in 2003 for not completing autopsy reports. Berkland's license to serve as a medical examiner in Florida was also withdrawn. Before arriving in Florida, Berkland was fired as a contract medical examiner in 1996 in Jackson County, Missouri, in a dispute over his caseload and autopsy reports. His doctor's license was ultimately revoked there, in Missouri. Pensacola's medical examiner's office said that the organs found in the storage unit appeared to have come from private autopsies Berkland performed between 1997 and 2007. A 10-year span. He performed those autopsies at funeral homes in the Florida Panhandle and in Tallahassee. Jeff Martin, who is the director of the medical examiner's office, said about 10 families have been notified of their relatives' remains that were in the unit. Now, this is the original report that came from it. And it gets deeper, guys, because I've actually found one of the cases that occurred in the area where I used to work in Florida, and I'm very familiar with the case. And I about freaked when I found the article that he was connected to this. This article is dated August the 29th of 2012. Now officials are trying to locate the family members of some of the victims. According to the officials at the medical examiner's office in Pensacola, the remains of more than 100 people were found stored in Tupperware containers, garbage bags, and drinking cups. Many of the organs were not labeled, making it difficult for officials to identify them. Formaldehyde, a chemical used to embalm and preserve bodies, was found leaking from a 32-ounce drinking cup that was holding a human heart. How horrible is it for the families of these deceased to think that someone's loved one's organs are basically rotting away in a storage unit somewhere? It's horrible. Meanwhile, no charges have been filed against Berkland, and his attorney, Eric Stevenson, declined to comment on Tuesday. This is not Berkland's first incident involving the misplacement of human organs. Before coming to Florida, he was fired as a contract medical examiner in 1996 in Jackson County, Missouri, over a dispute regarding his caseload and autopsy reports. Berkland had incorrectly stated on reports that he had taken sections of several brains to be preserved as specimens for medical conferences and teaching purposes, and he called them proofreading errors. At the time, Berkland contended that the actions against him were unfair because he had no evidence to present in his defense. In the meantime, it is not immediately known why the organs were stored in Uncle Bob's self-storage facility. Officials are now trying to determine whether or not Berkland actually broke any laws in Florida with regards to storing and disposing of human remains. All right, then that takes us over here to this article that was dated November the 15th of 2012. Prosecutors have added 4 misdemeanor theft charges to the Berkland case, saying he possessed those remains without the permission of the families. We will be arguing that while in some cases Dr. Berkland may have been authorized to perform autopsies, the body parts or organs he kept without the permission of the family constitutes theft. That was Greg Marcille, Chief Assistant State Attorney. Well, heck yeah. Marcille said because there is no way to put a value on a body part or a human organ, the latest theft charges against Berkland are second-degree misdemeanor, carrying a maximum sentence of 60 days in jail. Berkland was already facing a felony charge of improperly storing hazardous waste and a misdemeanor public nuisance charge. He was released from the Escambia County Jail on $10,000 bond and will face his next court hearing on January the 9th. This following video that you're about to watch, guess who was the medical examiner in the autopsy report?
The death of Sheena Morris was ruled a suicide more than 10 years ago in Bradenton Beach. But tonight, her family says new evidence proves what they have always believed, that Sheena did not kill herself. ABC 7's Taylor Torregano sat down with Morris's mother about the evidence that she says was always there, but possibly overlooked.
What happened to Sheena Morris? It's a question that's been asked for more than a decade now, and the answer depends on who you ask. The Bradenton Beach Police Department quickly determined she killed herself. The Florida Department of Law Enforcement did too. But now, new clues and old evidence have other experts certain Morris was murdered. January 1st, 2009, 2 a.m.
Hi, my name is Sheena. He left here probably about half an hour ago. I had deputies come out here because he did physically hurt me.
Sheena Morris tells the dispatcher police had already been called to the Bradenton Beach motel where she and her fiance, Joe Genoese, were staying. Neighbors had heard them fighting and called 911.
I filled out a police report here in Manatee County because he did make me bleed.
She then says she was calling police again to tell them Genoese had taken her entire purse and was now claiming he was on his way to trash her home.
Now he's like, I'm going to go to your house and ruin your house. You ruined my life.
2 p.m. Sheena Morris was found dead, hanging in the motel bathroom. Genoese says he left in the middle of the night to care for his daughter.
No, you left in the middle of the night because you murdered my daughter. Even in the crime scene photos, that purse shows back up in the room.
Sheena's mother, Kelly Osborne, never believed for a second that her daughter committed suicide. She says the police didn't even file the initial domestic abuse report.
That not being handled, I think they had to cover it up and make it a suicide, because that alone, them not handling the domestic dispute, she could still be alive.
Numerous other crime scene investigators and experts have looked at this case, including certified senior crime scene analyst Jan Johnson. She pored over the same photos everyone else did, but this time she noticed something different.
She had to have been in the chair, positioned in the chair for a period of time for that mark to have set in as a lividity pattern.
This lividity pattern that Johnson says can only happen after death.
That means the blood that's settled around, so she has to be in a fixed seated position in the chair for that pattern to have, basically, it's like tattooing.
When Johnson was finally able to measure the same chair that was in the motel room the night Sheena Morris died, she says it matched perfectly with those marks on Sheena's back, but it was nowhere near the bathroom where Sheena was found hanging. Is this a clear indication to you that Sheena did not commit suicide?
Yes, it is. How else would we explain that there's nothing in the shower, there's nothing on her clothing, there's nothing that's consistent with that pattern except for the chair in that condo?
And I'm like, oh my gosh, I just couldn't believe it.
But after all this time and what Osborne calls intentional negligence by Florida law enforcement, she's lost all faith that they're even interested in justice for Sheena.
You know, at first, a lot of people say to you, time will heal. And that is absolutely not true. Time never heals. As a matter of fact, as time goes on, it gets harder and harder and harder because you miss them that much more.
Osborne tells me at this point, she's hoping for somebody else to see this new evidence and open another investigation.
Okay, so I want to show you what area we're talking about here. You guys are all familiar with Orlando, Florida. Pretty much everybody is. Now, over to the southwest is Tampa. Down below that, you have St. Petersburg. Then you have the next biggest place is Sarasota. Bradenton is right here. This is where I used to work. I worked there for about, I think, 13 years in that area. This is where I did my insurance work. So Bradenton is a very small town. And these little islands right here, they're not the most popular. I mean, like Longboat Key is that's the richy rich, right? Lots of big people that have money there. That's actually, Longboat Key is where George Bush was. That's where he was staying. That's where his hotel was on the morning of 9/11. So connected to that is Bradenton Beach, Holmes Beach, and Anna Maria Island. Very small little islands, very quaint, in fact, this whole beach area right here, it's one of those that they don't even allow like big name companies to come in. It's all locally owned businesses. The reason I'm showing you guys this is because I want to show you where this is, and then straight up here, you go up north of Florida to the Panhandle, all the way over. There's Tallahassee. And then you go all the way over here. This is where I live, in this area. And it doesn't, you have to click. Here's Pensacola. This is where James Owens is. This is where he's out of, this area right here. So this was where Dr. Berkland, I guess this is where he lives now. But apparently he was doing some work down in Manatee County at one point in time. Now, this article that I'm going to read you guys now comes from The Islander, and it's a very tiny little news magazine that Anna Maria Island puts out, okay? It says, bizarre discovery relates to Morris investigation. Past firings and a gruesome discovery of preserved human organs found in a Pensacola storage unit last week have raised concerns regarding Dr. Michael Berkland's involvement in the investigation of the 2009 death of 22-year-old Sheena Morris at a Bradenton Beach motel. Now let's read this part. Previous to the gruesome discovery, Berkland played a pivotal role in the decision by the Florida Department of Law Enforcement to review Morris's death. Morris was found dead New Year's Day 2009 in her Bridgewalk Resort bathroom, hanging from a dog leash in the shower. The case was initially ruled a suicide after the Bradenton Police Department and Manatee County Sheriff's Office found no evidence of foul play. In 2011, Berkland was hired by Morris's mother, Kelly Osborne, to further investigate her daughter's cause of death. Berkland determined from photos of the crime scene that it could have been staged to look as if it was a suicide. It was his opinion that swayed the medical examiner to change the cause of death from suicide to be undetermined. But that opinion is being questioned after last week's discovery and new information that Berkland has twice been fired from medical examiner jobs, including a 2003 dismissal from the Pensacola District 1 Medical Examiner's Office, which now is involved in investigating the macabre discovery in Berkland's storage unit. So what did this man do to this mother? Did he give her false hope? For those who first investigated Morris's death, the impact of last week's find and the information regarding Berkland's employment history is clear. I'm very concerned about this because this is the expert that convinced everybody the crime scene was staged, says Bradenton Police Chief Sam Special. His department had been taking criticism from the mother and her supporters. The police continue to say, they have been telling us for 3 years that he's an expert to base facts on, and here he is falsely documenting. This guy's word is totally discredited. He also said he was stunned at the turn of events, but I'm sure we will find out more in the coming days, and the basis of his opinion is what started this, and he has no credibility. They said the Pensacola investigation won't change FDLE's review process of the Morris case. They sealed the case last month, and they're assembling a team that is expected to begin reviewing the case next month. FDLE is not using his opinion in their review. It was Berkland's opinion that is the basis of this process, but his opinion has no credibility. Florida Department of Law Enforcement will base their review solely on the facts of this case. Now, the mom says that she previously knew of Berkland's employment history and now has been made very aware of the discoveries in the storage unit, but neither has caused her confidence in him to waver. She said, we did not know about his background when we checked him out before hiring him. We looked at both sides of the story, and we believe his dismissals were politically motivated as stated in the past. She said that the discovery of the organs in Berkland's storage unit took a little more time to digest. I had to let the news sink in for a day. After thinking about it, I feel bad for the families whose family members may have organs in that storage unit. But it's no different than my daughter's body parts rotting away in the Bradenton Beach Police Department non-climate controlled evidence room. Morris's fingernails were clipped at the crime scene and retained as part of the case file. Osborne believes her daughter was murdered and has questions why Morris's fingernails have not been tested for DNA. She had a tumultuous relationship with her boyfriend, and the mom she's got that, mamas always know. Something wasn't right. You could also be dealing with family members too that don't want to believe that their person would give up, She further says that my understanding is that Dr. Berkland used organs in his teaching as well, which is why he had them stored. At this point, I have no reason not to believe he is a professional criminal pathologist, and what has happened hasn't changed my opinion of him and hasn't changed the fact that my daughter was murdered. She said, I'm frustrated with the lack of communication from Florida Department of Law Enforcement and the Bradenton Beach Police Department. There's been no communication at all. They've made a comment. The chief made a comment that he won't talk to me because I berated him. This is absolutely not the case. I am capable of having an adult conversation when it comes to my daughter. Osborne said Bradenton Beach Police Department is incapable of handling a homicide investigation. I will say this. That area, you don't see a lot of stuff like that happen down there. It is kind of a little, this is very much out of the norm. But Dr. Berkland is a criminal pathologist and is qualified to make this determination. And the fact hasn't changed that 3 other pathologists agreed with Dr. Berkland's findings. 3 forensic experts were contacted by Berkland to review the crime scene photos. Berkland's attorney, Eric Stevenson, told the Sarasota Herald Tribune that Berkland's storage of organs is no different than a lawyer storing case files. The only difference, he said, was that the difference in profession and that this incident has no bearing on the Morris investigation. And that is where we are today with Berkland. I'm going to keep diving because I want to see what this guy has on him. I want to know. Do we need to dive further? Please let me know in the chat. So that's what I've gotten so far, and that's just from last night and this morning. So I know I'm going to find more on him.
So
but I thought it was interesting. They said dismissal was politically. He had told people that his dismissal from both the ME's office was politically motivated, and I'm curious to see if that's what we're going to hear from James Owens.
So tell us again how this doctor is related to Sarah's case.
They are wanting to hire him as their expert witness in the crime scene reconstruction. We think that he's going to be one of the ones that gets brought in to speak about how George's injuries occurred.
Mm-hmm. He's the one that they're calling a death investigator, yeah.
Yeah. And you know, it's funny because we all speculate that George went down the steps, right, in the suitcase.
I believe that. I believe he did.
We all say that, but what if he did? What if the state gets up there and they have something a little different? We're going to be like, what? Because we're also used to saying that about,
Owens was putting out there today, and I'm learning that he really does like to exaggerate. He was saying that now they're saying that George could have sustained those injuries to his head 36 to 48 hours before he died.
Yeah, but they got a Publix
receipt.
They have a Publix receipt that's going to show that, and we can see. I think that's what those witnesses are going to say, is that he didn't have any injuries on him. Well, on his face.
They can find them. It sounds like they're having trouble finding the witnesses.
Well,
which is what happens when you wait this long to take a case to trial.
Mm-hmm.
Witnesses disappear.
Okay, so I don't want to cut everybody off, but I think I got to cut everybody off because we're not getting any more legal questions for Sam, and Sam's got to go back to work, and I've got to go over and take care of my uncle. So, the next thing we're going to do is I've got to get with Tyler now because we're going to do another interview. He was the one that lived in the neighborhood.
Mm-hmm.
So I've got all y'all's questions. Everybody put some questions together for me, and I'm going to put them all together, and I'm going to do a recording with Tyler, and we'll put that out soon. I would say in the next couple of days or so. I just got to get a hold of him and pin him down for some time to record.
You guys check out the Buy Me a Coffee for Carrie. She's put up tons of cool stuff for you behind the scenes. So you guys buy her a cup of coffee and you'll get access back there.
This is
contribute to the channel.
Yeah, this is what we're kind of trying to do. Let me show you guys really quickly. This is what it's kind of a Discord. And so what we'd like to do is get away from memberships through YouTube and doing memberships through this little thing, because I feel like we can do a whole lot more here. We have areas where we can put posts and you guys can get all kinds of good stuff from us. I've got some cool pictures that we did based on the ME report. Mm-hmm. We've got measurements. We've got private emails. We've got, I post every time I put a video up, I send a post out to you guys and tell you that it's hitting now or it's going live now. And I know a lot of people will like that a lot.
Mm-hmm.
Membership starts, let me show you this. There's 4 levels of membership. And it's $1, $5, $10, or $20. And the thing is, whether you pay $20 or whether you pay $1, you get the same thing when you're on this membership plan. It's just a matter of how much you want to contribute to being part of our little crime community. So, it's just a little bit more. It's more private for us than YouTube. What?
Will they be able to find any of the stuff we talked about for the Marsha Thompson trial and the cases and things that were mentioned today in Sarah's? Will they be able to find that there?
Yes, I should be able to get that up in the next couple of days. As I go here, so what's happened in the last couple of days is I've gotten all this stuff built up that I've got to edit and get up on the website and everything. So I'm going to be spending my time doing that. And our next video, I don't even know what I'm putting up tomorrow, but it's probably going to be the continuation of what you and I did night before last, Sam. So
okay.
But
All right.
yeah, you can get the link to the Buy Me a Coffee. It's up in the, I got it pinned up in the comment section. So if you just go to the top of the comment section, you'll see it up there. It's also in all of the descriptions of all of our videos.
Thank you so much for having me. Thank you guys for hanging in to the Sarah Boone circus.
You know what, Sam? Everybody seems really happy to have you here and answering all of our questions, and I really appreciate you. I know they do, and they were like, "Thank God," because you should hear some of the stuff that comes out of Carrie's mouth.
Well, I'm sure you keep them highly entertained.
They're like, "Okay, thanks, Carrie. We're gonna go over and watch a lawyer now and get some real information." Thanks for the laughs, Carrie.
Well, we do need a little bit of humor in this craziness for sure.
You guys,
That
this is going to turn, Sam, it's going to turn into a jet show. This trial is going to be crazy, and we've got to be prepared for it. And there's so much between now and then. Judge, I'm just not prepared for it, Judge. Judge, I just don't have much time, Judge. I got on this late, Judge. I got to get so much done.
I know. I have a job.
Yeah, you have a job too. This is my job. You already
I
have a second job.
I have a case going to trial, I think in November. But it's fine. The cool thing about doing what I do and being my own boss is I can work in the middle of the night if I want and then sit on a trial stream all day long, which I have been known to do.
Yeah.
Mhm.
And see,
I
that's where
but I get
I'm
caught
messed
up in the trials. Not all of them, but some of them I get caught up in. And then I'm like, oh shit, I sat there and watched that all day long and now I've got to do my own work.
Yeah, I like to work at night. I work best at night, and I haven't been able to keep that schedule lately with having to be, they want me to go out into the daylight and do things during the day now. And I'm like, how do I do that and have my nighttime where I can work? It's messing me up. But yeah, you guys give a big shout out to Laura and Bama Green Eyes and for their interest. Laura's interesting captures. You can go over and check out her channel. Thank you both you guys for moderating. I know it's getting a little bit thicker in here, ladies. Were y'all able to handle it okay? I don't think we had anybody that shouldn't have been here in here. So
they were great. You guys, as you leave, thank you so much, and don't forget to leave a like on the video.
Yes, please smack that like button like it's Sarah's head on the way out.
All right. Well, I'll see you later, Carrie.
Thanks. You guys be good. Bye.
Bye.
Thanks for watching, everyone. If you enjoyed this video, please do not forget to like and subscribe on your way out, and feel free to leave a comment. Have a blessed day.